Testing, testing. We are on standby, honey. Testing, testing. Let me see. Good afternoon, everybody. All right, so good afternoon. And usually on Tuesdays, right, when the judge is live on this channel, it is his space. However, this is a special programming because today Terrence Bradley will be taking a stand to testify against Fani Willis and Nathan Wade. Um, and the reason for that, is the Judge McAfee, he revoked client lawyer privilege. So the expected testimony today from Terrence Bradley, he is the former law partner and divorce attorney for Special Prosecutor Nathan Wade, could be a consequential moment in Fulton County case. We're just waiting, and actually, you are cutting. I'm cutting in and out. Wait. All right, let me check something. Testing, testing. Oh, I had the other audio on. Sorry about that. That was me. Sorry. Oh, I had the other audio on. Sorry about that. That was me. Sorry. Yeah, I had the show playing in the background on the computer. So that's what you saw, like double speaking. That was the in and out. My apologies. Now I have an echo. Let me see. The in and out. My apologies. It should be no echo now. I have an echo. It should be no echo now. Wait a minute. Oh God. Okay, I'm good now. Thank you. All right, here we go.
All right, we are back on the record with 23 SC 188947. If we could have counsel starting with the state identify themselves for the record for the purpose of today.
Adam Avadi for the state, Your Honor.
All right, and in order of the styling, let's start with former President Trump. I think we have Mr. Sadow on Zoom.
You do, Your Honor. Good afternoon. Steve Sadow for President Trump. We waive his presence, and I believe Ms. Little is also on Zoom. And
okay, thank you, Mr. Sadow. On behalf of Mr. Giuliani.
Alan Stockton on behalf of Mayor Giuliani. I think David Lewis and John Esposito may be on Zoom as well. And we waive his presence.
There we go. On behalf of Mr. Meadows.
Your Honor, Jim Durham on behalf of Mr. Meadows, and he waives his appearance.
Thank you, Mr. Durham. On behalf of Mr. Clark.
Attorney McDougall, Your Honor, and he also waives his appearance.
Thank you, Mr. McDougall. On behalf of Mr. Chile.
Good afternoon, Your Honor. Richard Rice, President Court, Chris Anulowitz is on Zoom, and Mr. Chile waives his presence.
Thank you. On behalf of Mr. Roman.
Good afternoon, Judge Ashley and John Merchant, on behalf of Mr. Roman, and he waives his presence.
All right, on behalf of Mr. Schaefer.
Greg Gillen and Anthony Lake on behalf of Mr. Schaefer, and he waives his presence.
On behalf of Mr. Floyd.
Morning, Your Honor. Good afternoon, Your Honor. Chris Kachuroff and Mr. Floyd. We also waive Mr. Floyd's appearance.
Thank you, Mr. Kachuroff. And on behalf of Ms. Latham. Anybody here on behalf of Ms. Latham? All right, I know before we'd had Mr. Cromwell, and I had not heard anything from him. I don't know if any other parties have as well, but.
Your Honor, I believe Mr. Cromwell is in a deposition in South Georgia. That's all I know.
All right.
There's a Zoom participant, Mr. Cromwell.
Looked like he joined.
Okay, that's helpful to know. Mr. Cromwell, can you hear us? All right. Well, we'll keep an eye on that to see if he does join us, and we'll take it up as it comes. So, just a few preliminaries. First of all, I'm a bit under the weather, so I'll try to speak up, but if anyone can't hear me, just let me know. I'll try to talk close to the microphone. But we are here today, the sole purpose of which is that at the conclusion of the hearing on February 16th, I announced that I'd be meeting with Mr. Bradley in camera to assess Mr. Wade, and particularly that it wasn't established that his specific knowledge came about in furtherance of legal advice. So having made that determination, I didn't see any other choice but to allow the parties to have an opportunity to explore that topic with him. There's really, in my mind, it's that topic only. I think that if there's anything else we've already covered, I'm not here to do it again. So with that, is there anything else we need to cover before kicking that off?
Just, Mr. Wade, he's still a potential witness, I would assume. And so he needs to still be excused. We would invoke the rule, continuing rule.
Mr. Abadi?
I believe Mr. Wade was released from his subpoena when we concluded his testimony at the last hearing. So unless he's been re-subpoenaed, and I have no knowledge of that, he has every right to be present.
Sure. I think procedurally that would be accurate. And so I at this point, I don't see a means where he would need to be recalled. And but if it is, then that is something you can take up. All right. Mr. Bradley, through his attorney, had informed me that he would be here today in person. I don't see him in the gallery. Do we know if he's out in the hallway? Okay. All right. If we could call for Mr. Bradley.
Judge, would it be permissible to sit in the jury box?
That's fine. All right, Mr. Bradley, Deputy Scott will swear you in again.
Well, that's what you should give to the court, would be the truth, nothing but the truth to help you.
I do.
Please be seated. Case is fairly close and last name for the court.
Terrence Bradley, Terrence, Bradley, Bradley.
Ms. Merchant.
Thank you, Judge. Good afternoon, Mr. Bradley.
Good afternoon.
Good to see you. Sorry, under these circumstances. I'm going to just go straight to where we left off before. Fani Willis and Nathan Wade were in a romantic relationship, correct?
Correct.
And it began at the time that they were both municipal court judges, correct?
Objection, Your Honor, based on privilege. That was covered in the attorney.
Okay, overruled.
I do not have knowledge of it starting or when it started.
Terrence, you told me that it started when they were both municipal court judges, though, correct?
That is incorrect.
You never confirmed in writing that it was, instead of magistrate court, it was in municipal court when they started dating?
If you're speaking of the text message, you can go to that text message and
I said no. Municipal court, nothing else.
I'm referring to a different conversation. I asked you, do you think it started before she hired him?
And I'm going to object. This was covered in the previous hearing where Mr. Bradley said he had no personal knowledge of the exact text that Ms. Merchant is speaking of and actually used in an attempt to refresh his recollection. And he explained exactly what he's explaining here before the court. So this is repetitive and unnecessary. So I would object to asked and answered and relevance at this point.
All right, perhaps we'll get there, but I think first Ms. Merchant has the right to draw his attention to the exact potentially inconsistent statement.
Thank you, Judge. May I approach him?
So overruled.
This
You
is
may.
the text I can use.
And for purposes of the record, I believe Ms. Merchant, you tendered, was it the entire text chain as an exhibit?
I only tendered a few of the texts, but I did give the state their courtesy copies last time of the exhibits.
Was this one tendered?
This one was not tendered.
All right.
And I'm happy to tender it.
Well, we'll just take it as it comes, whatever you.
We're at, I think we're at 39. I will wait to mark it, but I think we're at 39. May I approach it?
You may.
Hired him and you responded absolutely.
Your Honor, I'm going to object as to the source of the information that Mr. Bradley allegedly gathered this from. There's been absolutely no foundation, and based on the arguments at the last hearing, that a lot of this is based on gossip, innuendo, assumption, and privileged information. And at this point, Ms. Merchant has not provided a foundation as to how Mr. Bradley would have any information that she keeps referring to.
All right, I think that's, go ahead, Ms. Merchant.
I didn't ask him about the source of the information. And under Rule 621, I can impeach him with any inconsistent facts. This is an inconsistent fact. I can impeach him with any contrary facts.
Sure.
This is a
Why would it
contrary
be
fact.
a relevant impeachment if he actually has no personal knowledge of this?
If he doesn't.
Sure.
have
So
personal
I think you have to lay that foundation then, so that'll be sustained.
Do you remember telling me that it began?
Well, that doesn't address the issue.
I'm not, I was just asking if you remember telling me as opposed to the
Okay,
text.
sure.
Do you remember telling me that it began?
Well, no, and then you're going into the substance of it, which we haven't determined whether he actually knows or how he knows.
You told me, in fact, you corrected me when I said magistrate court. You corrected me and said it was municipal court. Do you
Yeah.
remember that?
Same objection, Your Honor.
This is the exact same issue, right?
Well, I'm
Yeah,
asking if he remembers that. He hasn't answered that question yet.
right, but the relevance of whether he remembers it isn't established until we know how he remembers it or why he knows it. If that makes sense. I guess not.
Sorry, how he knows it. I'm just asking if he told me that.
Right.
So I wasn't asking how he knew that. I wasn't asking the source of that knowledge. I was asking if he told me that. That
Sure.
was it.
But that's the point. It's how he knows it.
Right.
The source of his knowledge, the state would contend is hearsay because it's gossip and innuendo, which is what was indicated the last year.
Well, it may not be hearsay. It may not be gossip. We haven't really gotten there yet. We don't know how he knows what apparently he's telling her. And I think we need to figure that out before we can go any further.
Yes. And if the source of the information is a witness who've testified, then it's not hearsay. So when did the relationship start?
I cannot answer that.
When was your first knowledge of the relationship?
Objection, Your Honor. He's already answered that question multiple times today. He said he has no idea the timeline or when it occurred. That was one of the first questions that Ms. Merchant asked.
I didn't ask when, I asked his first knowledge. He testified he has knowledge that they had a relationship. I asked him when he first got knowledge of that.
Okay. So if the question is, when did you first get knowledge? I think we can start there.
That was the question. Yes.
All right.
Thank you. When did you first get knowledge of their relationship?
I've said over again that I didn't have any personal information where I could personally say when it started. I've said that time and time again. So I don't know when the relationship started.
And that wasn't my question. So my question is, when did you first gain knowledge? I didn't ask the source of the knowledge, didn't ask you to comment on the validity of the knowledge. I asked when you first had knowledge.
We'll get to the how, Mr. Abadi. So I'll note the objection, overrule it. You can answer that.
And just for the record, and I appreciate your honesty, but he said he had no personal knowledge, so he had to gain the knowledge from hearsay.
He could have gained it from
Sure.
Mr. Wade.
Well, I mean, most of us learn things from hearsay. The question of whether it's admissible, right? And that's what we got to get to. So
I apologize.
When did you first get knowledge? I'm not qualifying what type of knowledge. I'm just asking when you first knew about the relationship.
I don't know how to answer that. I mean, so I can't give you a date if you're asking for a date. If you're asking me, how did I get the knowledge? It would have come directly from my client.
Right.
So help me understand.
I think you say you can't answer that question. You don't know the date. So that's the answer to the question.
But I said that 5 minutes ago.
We have to make it clear.
Yes,
All
sir.
right. Next question, Ms. Merchant.
So you don't know the specific date.
No.
Do you know if can we narrow down the timeline? Did you gain knowledge in 2019 of this relationship beginning?
I'm going to object to this line of questioning as he said he does not know
Sure.
when he gained
All right.
knowledge.
He doesn't know the specific
That's
date.
fine, Ms. Merchant. I think I'm overruling that. I think we can try to see if he can narrow it down based on goalposts.
Thank you.
19, I would probably say no. I mean, I don't have anything that there wasn't a specific date. There wasn't a football game. There wasn't something that I can attribute to him telling me whatever. And so you're asking for a date, you're asking for a year, it's still a date. And at this time, I am telling you that I do not have the date.
Let's try this then. So you received a contract from Ms. Willis, January 2021, correct?
Can I see the,
Yes,
I think so.
Exhibits are, I think, okay.
I think if it was from the exhibits, I think it was 21, yes.
And I don't want to belabor the point. We did those
Yes.
when you were here before.
Yes.
If those documents that you looked at last time
Yes,
said January 2022, that's okay.
21. I
I'm
didn't,
sorry, 21. You're right. Thank
and
you.
it was, I think, renewed in 22.
It was, yes. So the contract date was that we have in the record is January 25th, 2022. So using that date, at that point, had they begun their romantic relationship?
Of 2022,
January 25th, 2022, 2021, I'm sorry. When you got your first contract?
I don't recall. I don't recall any specific dates. No, ma'am.
You remember when you got that contract though, correct?
I remember I had the contract. Yes,
Okay. And you told us last week, or I guess it was the week before now, you told us that Mr. Wade brought you that contract, essentially told you about that contract.
that is correct.
So Ms. Willis is not the one that brought that contract to you directly. It was Mr. Wade.
That is correct.
At that point in time, they were already engaged in a relationship though,
I'm going
correct?
to object, Your
I
Honor.
can't say that.
Characterization of what Mr. Bradley just said. He just said he does not remember. There's nothing specific.
He doesn't remember the exact date. And I think the question now is to reference it or tie it to maybe some other event that he might remember.
I agree with Your Honor. She asked that specific question. He said he does not remember any specific dates after signing the contract. That's exactly
Sure.
what he just said. This is
All
asked and answered.
I know, and we're getting to the end of it. So, Ms. Merchant, you don't have much more to pull on here, but he answered that last question. So what's your next one?
And Judge, I didn't hear the answer if they were in a relationship January 25th,
Mr.
2021.
Bradley, do you recall the question?
I recall the question, and I can't tell you accurately whether or not they were in a relationship at the time. You asked me about him bringing me a contract. I said he did bring me a contract, and that is accurate.
Do you remember knowing Ms. Willis prior to her taking office as the DA?
I had very little contact with Miss Willis. I knew her through my business of coming down to Fulton, if that's what you're asking. Yes.
You knew her through the business. So you had met her prior to your contract?
I'm going to object to relevance at this point as to why we're here today.
Sure.
Judge, he doesn't remember much of anything right now. And so I'm trying to create a timeline to hopefully piece this together.
All right, well, I'm not seeing really the likelihood that that's going to have any success. I'll let you ask a few more questions, but if he doesn't have a date, then I don't know that you're going to be able to create one today.
Okay, thank you. So the time that you had this contract from January 2021 until January 2022, did you come in and out of the DA's office?
Yes,
Okay, and so were you able to witness Mr. Wade and Ms. Willis interact during that time?
I'm going to object. This has been asked and answered. It was addressed at the last hearing about Mr. Bradley's access to and from a specific room to pick up files. And Mr. Bradley said that
Sure.
he rarely saw them together, but this was
Yeah,
answered.
I think the only avenue that was closed at the last hearing was his personal knowledge, potentially through, well, actually, no, if he testified, it was that he had no personal knowledge. It's knowledge that conveyed to him that was cut off at the last hearing. That's really the only thing we hadn't been able to explore, unless you correct me if I'm wrong,
Knowledge that was conveyed to him by,
by somebody else. That's that he claimed at the time was privilege. I found that it's not. That's what we're here to explore.
okay. Do you remember telling me that not many people knew where they met?
I'm going to object as to relevance, as to his personal knowledge, which is what 602 requires.
Yeah, I mean, we're back to the same point, Ms. Merchant.
His personal knowledge is what I'm asking him, what he told me.
But he hasn't yet told you how he knows that. And so unless you can establish why he should be testifying on this at all, then there's no relevance.
And I don't know how he knows that. That would be
Then
the
ask
next
him.
That would be the next question.
Then
But
ask him how he knows it.
I first have to establish that he said that.
No, you don't. You could go the other way around.
When you told me that it started when she left the DA's office and was a judge in South Fulton, where did you gain that knowledge from?
Well, I'm going to object because his testimony a few minutes ago is that he did not recall making that statement.
I'll overrule that. Mr. Bradley, answer the question if you can.
repeat the question.
When you told me that their relationship started when she left the DA's office and was a judge in South Fulton, where did you obtain that knowledge from?
I was speculating. I didn't have a, no one told me I was speculating.
No one told you that?
No one told me that.
You were speculating based on things that had been told to you or things you had observed?
So I'm going to object as to the nature of this line of questioning because the witness has made it clear he was speculating as to how or what he knew. And if it's speculation, it's inadmissible before this court.
All right, but the motivations for his reason for speculating would be admissible, so I'll overrule that.
Thank you, Judge. Was this speculation when you told me that? Was that based on things that had been told to you and things that you had witnessed?
I never witnessed anything. So, it was speculation. I can't tell you anything specific, if that's what you're asking.
Tell me anything specific as to why you speculated about that?
No, this was however many years ago. I mean, I don't recall, but no, I don't.
Did you have any reason why?
I don't know if speculation is lying, but
Well, let me just show me where in this text it says you're speculating. Or
you didn't ask me if I was speculating or guessing.
I didn't ask you, but tell me if it says anywhere here that
No,
it's speculation.
If this is the same one that you just showed me, it does not.
And you're welcome if you need to look at your text. Is there anywhere in here that indicates that you didn't have knowledge of the
No.
relationship?
Your Honor, I'm going to object. The line of questioning Your Honor directed counsel to explore is where he got the knowledge. She's explored that. He said it's speculation and he didn't get it from any source other than his own speculation.
Sure,
So
I think we're fleshing that out, and I think it's her right to have a little leeway on this if he's an adverse witness.
Thank you, Judge. And Judge, these speaking objections are clearly coaching the witness because he's regurgitating.
Your Honor, I
What-
object and take offense to that comment. I'm objecting based on the law, and I'm making a record for the court.
All right.
So I take offense to that comment. It's not the case.
All right. Well, I think we can start with objection, the grounds, and the rule number, and then if I need more, I'll ask.
Thank you.
All right.
Thank you. What did Nathan tell you about the relationship?
Objection, hearsay.
Nathan has testified. It's
Yeah.
not hearsay.
It's still hearsay. It's an out-of-court statement being brought in for the truth of the matter asserted. So hearsay.
Judge,
All right. Yeah, this would be for impeachment by contradiction, which would
Thank
be an
you.
exception to the hearsay rule, and admissible as substantive evidence, and the privilege issues are overruled.
thank you, Judge.
Well, I think you just overruled the privilege objection, but we don't know when he's talking about. So we've already established the December
Right.
2018 date of privilege.
Sure. And that's something I covered in the in-camera hearing, and I'm, based on what he told me in that in-camera hearing, I don't believe any statements to this effect were covered by privilege.
And Judge, I just want for the record, because sometimes the record doesn't reflect where people are looking, and that when I ask a question, Mr. Bradley is looking at Mr. Wade and his lawyer to wait for them to object, and they're clearly interacting somehow in the court. So I just want the record to reflect that because it wouldn't otherwise.
It's there now.
Thank you.
Do you have a question was put to you, Mr. Bradley?
Judge, one of my lawyers is sitting right in the back, that's
We don't have to go
behind.
down that rabbit hole. You can look wherever you want.
Yeah, and I'd never looked at Mr. Wade or his attorneys. That sounds true.
All right. Mr. Bradley, question was put to you.
Repeat the question, please.
Yes, so I showed you, or I asked you, I'm sorry, the last question I asked you was, what did Nathan Wade tell you about the relationship?
Same objection, Your Honor.
And that's already been ruled upon.
I recall him stating that at some point they were dating. I can't tell you what date that was. It was made in confidence. We were in the back of our office. Our offices were the only two in the back. There was no one else present. That is all I can tell you at this time.
One time?
One time.
You only had a conversation with him one time about the relationship?
Objection, asked and answered.
No, I think that's a clarify for a thorough and sifting cross. Ms. Merchant.
I do not recall any other time that he mentioned that they were in a relationship. No.
You may not. He ruled that he was. Okay. So you talked about this one time, and you said you don't know when it was though, correct?
That is correct.
Was it before Mr. Wade, before you got the contract in Fulton County? Let's start with that.
I do not recall.
Okay. And how did it come up?
Say again.
How did it come up?
I do not recall how it came up. It was in the back. I know where it occurred. In our offices in the back. I can't tell you what we were discussing prior to that.
Okay. Did you receive an email from me on January 6th with a motion attached?
I think I did. Yes. Yes. I know I received I don't know if the date is January 6th, but yes, I received that.
Okay.
Yes.
So you remember receiving that?
Yes.
With the date. And you reviewed it, and then you and I spoke about it. Do you recall that?
Do we speak over the phone or are you saying through a text?
That's what I'm asking you. If you
I
recall
can't
speaking-
remember whether it was text or phone or
But you recall us speaking, one way or another.
one way or another. Yes.
And where I was trying to confirm the facts in that filing.
I think I remember there was a line of about the accuracy of how much money that my office, the law office of Terrence Bradley, have received, and whether or not that was going to be in the motion or not.
There wasn't a discrepancy. I had kept that out. You asked me to step back in, correct?
I recall you, that may be accurate, yes.
And you thought, because you thought it might be suspicious if you were left out of the motion.
No, I think we discussed that it should reflect the accuracy, because the accuracy was that I received, I had a contract and received 74,000. And I think you had put in there that Mr. Campbell had received a certain amount, and then you also had put in there that Mr. Wade had received a certain amount, but there was not anything in there originally. And I said that it needed to be accurate. I needed to be accurate as far as that I had received 74,000. That's correct.
Because you did not want anyone knowing that you had talked to me.
I'm gonna object this to relevance.
Be biased. Overruled.
I wanted you to be accurate as far as the accuracy of our message or your filing.
Okay, so that was your interest was in accuracy in the filing.
I didn't reach out to you and say, send me a copy of your motion.
Right.
I didn't reach out to you to say that that I'm going to be in your motion.
Right. I asked you to review it for accuracy.
For accuracy. And I just stated that it was inaccurate.
And the inaccuracy that you pointed out was the thing about how much you had made.
That was the inaccuracy that I saw that jumped out, was the fact that I saw that I was left out when you had put the firm, the money was. I did not, when I responded to that, it was for that specific reason.
Okay. And I agreed I would put that back in, that section back in, and I did.
Correct.
I did put it back in, and I sent it to you again.
I don't recall getting a second email from you, no.
But you were happy that I put it back in, or that I agreed to put it back in.
I'm gonna object this to relevance.
Yeah, we need to get to more material aspects.
Yes, Judge, I'm moving along, I promise. So you did ask me to put that back in.
Again,
Well,
asked and answered relevance.
well, he didn't answer that last question, so overruled.
You did, can you confirm you did ask me to put that back in for it to be accurate?
Yes, that's correct. I said that, yes.
Okay. And then I asked you if everything was accurate, and you said, looks good. Correct?
I recall you asking that, but the looks good was applying to the accuracy of the 74,000. That's it.
So when you reviewed the motion and you specifically pointed out that one thing that you found inaccurate, you didn't point anything else out that you found inaccurate in that motion though, correct?
No, I did not.
And that motion alleged that their relationship began when Ms. Willis was in municipal court.
If I can reread the motion, but I don't recall, but if that's what it says. But I did my saying that it looks good was when you put back in the 74,000 into your motion.
Okay, and that wasn't what I was asking. What I was asking is, you didn't tell me that there was anything else inaccurate in the motion though, right?
But I didn't state that anything was accurate other than the 74,000.
Now, when I told you that I had this motion that I was preparing, you asked me to send a rough draft.
No, that's incorrect.
I approached Judge.
You may.
Which page are you showing?
They're not page numbered. It's January 6th.
I just see it.
Yeah, of course. I can show you if you saw the text.
I don't know.
Look and see if this refreshes your memory. So, we had been talking and you asked me to send you a rough draft and I told you, okay, but I didn't want it to be leaked before I filed it. Right?
That is correct. That is correct.
So you're the one that asked me to send a rough draft.
Yes, that's correct. Yes, that's correct.
That was at 10:08 on Saturday, January 6th. And then you got an email from me with that rough draft at 10:25 that same day, correct?
Yes.
If you need to look at it, I can.
If it says 10:25, then I know you sent me an email.
While he's looking at it, I'm going to object us to ask and answer. We've been through the fact that she sent him a copy of the motion, whether he specifically said rough draft or not, and then asked about the accuracy. He's explained his answer, and I've object to ask and answer. So
Understood, Mr. Vaughn. We're getting there. Overruled for now.
And then I responded when we were talking about that footnote that we were just talking about. I said, I took it out, but I can add it back. And you said, yes, add it back. You remember that?
I answered that, yes.
And then I said, anything else, anything that isn't accurate. And you responded, looks good. You recall that?
Let me see the,
And there, I don't know where the exhibits are. They were admitted. That refresh your mind?
it says looks good, but as I stated before, I was responding to you putting me back into the motion for receiving $74,000 in a contract.
This says, you said, yes, add it back. And then I said, anything else, anything that isn't accurate. And you responded, looks good. So you weren't responding to put it back in.
Your Honor, I'm going to object.
I
This is
know.
not his motion. He wasn't the affiant of the motion or verified. the
Overruled, Mr. Body.
Talking about his personal knowledge, Judge.
I've said
No personal knowledge.
twice.
Overruled, Mr. Body.
I've said twice that the looks accurate was, or I've said more than twice, was for the 74,000.
Do you remember telling me about Nathan and Fani coming to your office and spending time together at your office?
No, I mentioned, I do recall testifying on the 16th that she had come to our office.
And that was before she was elected as district attorney, correct?
I recall that that was when she was district attorney. Because I said that there was a meeting held at my office.
And who was at that meeting?
Now, I can't tell you that. I don't recall.
But you know, Miss Willis was there, Mr. Wade was there.
It was at our office. Actually, Miss Willis was there and there were other people there. Mr. Wade was not in that meeting. He was in the back. I wasn't even in that meeting.
Why did she hold it at your office then?
I have no idea.
You also remember telling me about them spending time together at her law office before she took her job.
I don't recall. Do you? I don't recall. Do you have something to?
Well, what I'm asking is, so let's back up a sec. So Ms. Willis rented a law office from the Evans firm or Andrew Evans and another lawyer, I think Stacy Evans. You have knowledge of that, correct?
I'm gonna object to hearsay.
If,
Well,
How does he know the information? That would be the correct question.
okay. Ms. Merchant?
I don't really know even how to respond to that. Hearsay, I'm asking if he knew that she rented
Yeah,
office
he may have been there. He may
Right.
have, may have seen a business card or something at some point. I think you can answer that.
I've never been to Miss Willis's office when she was in private practice. I've never dealt with where she rented. I didn't even know where her office was. So
Do you remember though, knowing that she rented an office
yes,
from the Evans?
yes,
You did know
that's,
that.
that,
Thank
that
you.
is correct. Yes.
Okay. And do you remember telling me that Mr. Wade and Miss Willis would rendezvous at that office?
I'm gonna object to, again, hearsay as to how he knows that information. He said he has no personal knowledge. And
He did
just-
not say he has no personal knowledge, Judge. He hasn't even answered it.
No, he said in general, he had no personal knowledge. So it's not been established the source of how he would know this because he said he's never been to her office.
All right. Ms. Merchant, if you, I know you're trying to impeach him by a prior inconsistent statement, but unless you can first back up and show why each statement is actually something that he had knowledge of, I don't know if this is going to be relevant.
And Judge, I'm not even there yet, but again, that a speaking objection. And so now I would anticipate what our response is going to be next. I didn't ask anything that was objectionable, but these objections are coaching the witness. I asked if he had knowledge. That's it. I didn't ask, did someone say this to you? I didn't ask, what did this person tell you? I asked if he knew.
Well, no, you're asking if you had knowledge and then you say of something specific. So,
Once I get an answer to that, if he has knowledge, then I will follow up with where that knowledge came
all
from.
right, well, let's try again.
So my question is, do you have knowledge of them meeting at that office?
Objection, foundation.
Okay, all right, overruled.
Do you have knowledge of them meeting at that office?
I have no personal knowledge if that's what you're asking.
I didn't ask that yet. I asked if you have any knowledge.
Objection, that would be hearsay.
Overruled.
Not if it came from
We
Mr.
don't
Wade,
know where it
Judge.
came from. So he said, how do you know, Mr. Bradley?
How do you know?
Any knowledge that I would have received would have come from my client at the time.
Okay, so you had knowledge of this place that Miss Willis worked. What did you know about them meeting at that office?
Objection, hearsay.
It's not hearsay,
Overruled.
Judge.
How he knows it, and then you ask the next question.
All right, he's already asked the next question.
Can you repeat the question?
Yes. How do you have knowledge? What knowledge did, well, you just told us. You told us Mr. Wade told you. So tell us what Mr. Wade told you about Miss Willis and Mr. Wade meeting at the Evans office.
Objection, Your Honor, privilege. This clearly covers the time after December 2018 that would be covered by the privilege.
Yeah, overruled. You recall the question, Mr. Bradley?
I do not.
If you re-ask the question, Ms. Merchant.
What did you learn from Mr. Wade? Because we've clarified that's where you learned it from. About Mr. Wade and Miss Willis meeting at the Evans office together.
I'm gonna object to asked and answered. He's testified that.
He hasn't answered. We haven't heard an answer.
He testified he had one conversation with Mr. Wade in the back of his law
Judge,
office.
Yeah, and his answer may change. So
Still in
overruled.
off as to how to answer the question.
That's
I can't recall what the conversation was. I do recall knowing that he would go down to the office or had been down to the office, but I can't tell you in what capacity or when or any of that. No,
Mr. Wade told you that they had sex at that office, though, correct?
I don't recall him stating that. No,
You don't recall
no.
it. So it's possible he did say that. You just don't remember one way or another?
I do not remember him saying that.
Do you recall that he had a garage door opener to either a house or a condo or something like that of Miss Willis's?
I've never seen a garage door opener. I've never been to Miss Willis's house. I've never been to, and I'm trying to explain, I've never been. So no, I do not have any personal knowledge of him having a garage door opener. Yes, ma'am.
I didn't ask if you had personal knowledge, like as in you saw it. Do you have any knowledge at all from Mr. Wade or any source that he had a garage door opener to access one of Miss Willis's residence?
And I'll object to any source as to hearsay.
All right, depends on the source. Overruled.
No, I don't have any knowledge.
So when you told me that, did you just make it up?
Do you have something that shows that I told you that?
Yes, well, if we're going to go through all the texts we can, but so was that made up though?
I'm gonna object because
I don't recall him having.
Mr. Bradley, just a
I'm gonna
second.
object under 106 as the rule of completeness. I don't have that text message or any text messages that indicate that, Your Honor.
And I don't have, if it was a text, we had that conversation. I actually think it was when he was on speakerphone and Mr. Merchant was there, but I'm not sure. But I mean, if I'm asked to qualify exactly where that's from, I would.
Okay, so rule of completeness would be if you need to introduce other text to show the context. If you're saying you haven't seen a copy yet, then I think Ms. Merchant needs to do that before you can
And I don't
decide your
have-
next step.
And that's what I was asking him. If that was something he just remembers making up. If he doesn't, then that's fine. But
She referenced text messages and started to go into her packet of papers.
Sure.
That have text.
So you don't have a text message to that?
I would need some time to look through, and I don't remember if I have a text to that or if it was during a conversation. It was one of those.
All right, well,
And
he has now said that he has no knowledge, so on to your next question.
Okay. Did Mr. Wade tell you about the trips that he and Miss Willis took?
No,
You have any knowledge of the trips that he and Miss Willis took?
Objection, hearsay.
Overruled.
I do now.
Okay, but you did not before this proceeding?
I did not know until you text that you found that in the deposition of his divorce. I mean, not deposition, but something from his divorce.
Okay. And when you responded, doesn't surprise me, they took many trips to Florida, Texas, California. Those are your words though, right?
I'm gonna object as to relevance. He said
Sure.
he did not know and he actually learned from Miss Merchant the information.
He said he learned about certain trips from Miss Merchant.
Okay, you can tie it down, but
Thank you.
we'll
He said he
see.
had no information about any trip that Miss Willis and Mr. Wade took. That he learned it all from Miss Merchant. That was his testimony.
Sure.
Judge, I'm
Maybe the
allowed,
conclusion we reach. I think she's going to ask more than one question, though. All right, Ms. Merchant.
and if Judge, just so we can be clear, if he said more than one version, that's all relevant. We're allowed to talk about the different versions that he's told.
All right, I've overruled the
Thank
objection,
you.
Ms. Merchant.
Do you remember telling me that it didn't surprise you that they took the trips that I found in the divorce file because they took many trips to Florida, Texas, California? And then you told me that they took the trip to California when she moved her daughter there because she failed out of FAMU. Do you remember that?
I don't recall that, but if I don't recall.
Okay. Judge, may I approach? It's
Sure. You may.
It's in one of the ones I gave you. Look at that. Let me know if it refreshes your memory.
So when that,
So just first, let me know if that refreshes your memory.
yes,
Okay.
yes.
So it's true that you told me that they took many trips to Florida, correct?
Per that, yes, but one of the messages is cut off and you asked about some other trips and I said, no, I didn't, I think. And that was specific to, at the top of that, it says, no, I didn't. And so that was to the trips that you asked me about. And I think before that, when you mentioned that you found all these trips, I think I said, oh, wow.
Yeah.
And
You did not know about all the trips that were taken, and you qualified it. You said, no, I didn't. When did it happen? And then the next text, which I can get, or you can look at your phone or whatever refreshes your memory, you said was after you left, after the firm was dissolved, correct?
Subject to relevance.
Overruled.
It was after the firm, the trips that you said, no, you didn't know about. You told me those were after your firm had dissolved, correct?
I think you mentioned that they were after I left, maybe, or whenever you found them. And I said, no, I didn't know about those trips. So
So you believe I mentioned that it was after you left?
I'm quite sure you have the text message, and I will refresh my memory.
Is it easier for you to refresh your memory with your own phone or with my printouts of screenshots?
Well, you have the printout, so I'll go.
Judge, the reason I'm asking is because I'm getting objections that I've cut things off, and it's just the nature of how you have to print out screenshots. So in order to avoid that, I'm happy for him to refresh his memory with his own phone, if that would be,
Well, I don't know if he's accepting your offer or not, so you're going
would
to
that be
proceed.
easier for you?
You can just provide the documents.
Okay. Let's see.
I have some water, Judge, please.
Yeah, let me see what we can do.
Sorry, Judge, I'm just trying to pull out all of the messages that he might need.
All right. Well, I don't really see, some point we're reaching the cumulative point where we don't need to go through an entire 6-month text chain. You're making the point that he'd made some comments to you along the way that led you to believe he had more knowledge than today he's testifying that he had. And so if you've hit the high points of that, then I don't know what else we can cover that actually moves the needle.
Okay, I'll move on to the actual trips then. So you told me that they took many trips to Florida. That refreshed your memory. Told me that. Was that based on your knowledge from Mr. Wade?
That would have been based on anything that my client would have told me. I didn't have personal knowledge of whether they went or not.
The trips to Texas, and you're the one who went to Texas. Was that based on your knowledge from Mr. Wade?
It would have been something that came from the client. I cannot tell you that I have any personal knowledge of any trip other than what would have been said by the client.
You went on these trips. I'm asking if you have knowledge from Mr. Wade. You also typed California. Was that something that you gained from knowledge from Mr. Wade?
It would have been from the client at this particular point. Yes, it would have been from the client.
And when you told me that the trip to California was to move her daughter out there, would that have been something you gained from Mr. Wade?
Thank you, Judge. Any knowledge that I have of any trip would have come from my client at the time.
You told us last week that Mr. Wade used your credit card one time. Do you know when that was?
I do not.
Relevance to why we're here today.
Well, I think this would be impeachment of Mr. Wade's testimony if Mr. Wade testified that he had never used anyone else's credit card
I
before.
object to ask him if he did because it was covered during the last hearing. You acknowledged that Mr. Wade used his credit card.
Judge,
So,
I asked when.
yes,
I did-
when? Okay.
I didn't ask, did he? I asked, when did he?
Let's go there.
I do not have any dates of when Mr. Wade used my credit card. I testified that we used the card for business and that throughout the business, we would order paper or supplies or filing of depositions. I mean, the cost factor of cases is what I said, and that still applies today. Did he use my credit card? He did, but I can't tell you who he used that card, what the trip was for. I can't even tell you at this time where he went.
He used it for a trip.
Yeah, it was for a trip, but I can't tell you where, when, why, or anything to that nature. Correct.
And he paid you back in cash.
I never testified that he paid me back in cash. I said that he would either pay me back. I said I couldn't remember. I do not recall. Sometimes he would write checks. Sometimes he would pay cash. And that still applies today, that I do not recall him paying me back cash, but I do recall him paying me back.
This was when you were still, before your partnership split up, correct?
It would have been before I left the firm. Yes. He wouldn't have used my card after I left the firm.
So we can at least narrow down the dates to that.
Of before I left the firm. Yes.
Okay, great. And Mr. Wade gave you details about meeting Miss Willis in Hateville or East Point, as it was called.
That's incorrect.
He did not tell you about that.
He didn't give me details.
He did not tell you about meeting with Miss Willis at an East Point or Hateville apartment?
At this time, I don't recall. No, I don't recall.
Where did you get that information from then?
He's testified he doesn't recall if he even had that information.
I asked if he got it from Mr. Wade, and he says he doesn't recall. So then I asked where he got it from.
I do not recall where I got the information from.
Okay. And you and Mr. Wade were friends as well as business partners, correct?
We were friends in the sense of I've known him for years. Yes, we were friends.
And you definitely did not want to come and be a witness in this case, correct?
That is correct.
And it was after, and we talked about this earlier, that Gabe Banks called you and then Nathan Wade called one of your friends. It was after that that you hired Mr. Chopra to assist you in this matter, correct?
Was it after that? So I hired Mr. Chopra and I hired Mr. Graham. Now, Mr. Graham is here, and when I received the subpoena, Mr. Graham was here at the last hearing, but he also had to go out of town, but he was present. Mr. Graham, I called, and I had started getting calls from media, and I told him to respond to the media, I think, and that was somewhere around whenever you subpoenaed me. So it was, I can't tell you that it was that instance of those calls for Mr. Chopra, but I had engaged Mr. Chopra and Mr. Graham at that time.
I'm going to ask the question again because I didn't get an answer to it. After you got the phone call from Gabe Banks and from Nathan Wade to your
I think it was before that, but however, I think it was before that is what I'm stating.
when you got from Gabe Banks, you called me immediately. Well, actually, you texted me and then you called me.
I didn't call you immediately, but yes, we did speak.
And you texted me about it as well.
That is correct.
And then we spoke after Mr. Wade called your friend, and we talked about that as well, correct?
That is correct.
And at that point, you didn't mention anything to me about being represented by Mr. Chopra.
But I didn't mention anything about Mr. Chopra or, that is correct.
Yes, that was only my question. Let's see. I'm going to show you two more texts. They're in the ones that you got.
All right, Ms. Merchant, we're going to do
Those are the
5 more
last
minutes.
2 questions. Thank you.
3:05, I'm cutting you off.
Thank you. May I approach? Show you a couple texts to refresh your memory, and then I want to ask you any questions.
Are these supposed to go together?
No.
Oh, these are two separate dates?
Completely different dates.
Okay, all right.
So I know we talked about the other occasions where you had the text or just about footnote. But do you recall me asking you, do you think it started before she hired him? And you said absolutely. Do you recall that?
I see that in the text message, yes.
Okay. And do you also recall me asking you how they would react if they would attack me? And you said, no, they will deny it.
Your Honor, objection as to speculation as to how he thinks they will react.
I think it goes to the motivations of the witness overall.
And you told me that they will deny it.
That's written in there, yes.
I just want to, one last opportunity. You're an officer of the court, correct?
I am.
And you're under oath today.
I am.
Is there any of your testimony from today or the previous days that you want to correct?
That I want to correct?
Yes.
No, I've told you everything that I've answered everything that you asked.
Thank you. Oh, Judge, just so co-counsel and the state can have them, for the record, I can admit those few that I showed. That would be.
Well, they weren't ever tendered,
And
so it's
in
just
case-
for,
I didn't know if they wanted
Right.
to use them, but I'll hold on to them.
if they need to be tendered at some point, then we can make them part of the record. All right, let me turn over to Mr. Sadow, if you're with us on Zoom.
Thank you, Honor. I do have a few questions. First thing I'd like to know is whether the court reporter has defense exhibits 26 and 27 from the last.
We have a different court reporter this time. We had to have someone else fill in on such short notice, but I can potentially send those to you if you need them.
Well, I think I have working copies, but I want to make sure that the witness has a copy to look at.
All right, we can try to work through that logistical challenge. This is, you said 26 and 27?
I believe that's correct. And 26, I think, is the same text messages that Ms. Merchant was just asking me about. It was 2 pages. I stapled it together, and it is dated January the 5th of this year.
All right. I can print off a copy now, but why don't we start off with the questions that you have?
Okay, because
I can
that's
do
where
it
I
here.
want. That's where I'm going to start, but I'll see what I can do to work through it.
It's not gonna work? Here, I'll email them to you. Okay. All right, Mr. State, why don't we start with your question, and we'll see if we actually need to get a copy of those exhibits in front of the witness.
All right. Mr. Bradley,
Yes, I'm here.
all of a sudden I've lost you on the screen. There we go. Well, you're on the Zoom. You're on YouTube, but you're not on the Zoom itself. But not that I can see.
I'm here. I can hear you.
No, I know. I think his visuals may be a little different, so hold tight, Mr. Sadao. We could try to correct that.
Yeah, he was on. He was on when Miss Merchant was asking questions.
We need
Able
to
to
add
see him.
I know, we need to add a spotlight to to the witness stand and a spotlight to Mr. Sadao, and we don't need all the other boxes.
There we go. Thank you very much.
Well, then hold tight, Mr. Sadao. We need to add you as well. All right, now we're ready.
Thank you, sir. Mr. Bradley, you have referred to Mr. Wade as your client, correct?
Correct.
You understand that the court has ruled that communications that you had with Mr. Wade are not privileged, correct?
No, I'm aware that the court ruled that one specific dealing with the time frame of one specific conversation wasn't privileged.
Then I'm going to ask Your Honor, if it's that the limitation or
Excuse me. To clarify, I think, sure,
Sorry.
Mr. Sadot, you asked whether all communications with Mr. Wade, I think, were covered. That was not the extent of the ruling. The only ones that I deemed were not covered and that I'd asked about in the in-camera hearing, because those are the ones that were relevant, were any communications Mr. Wade made regarding the existence or non-existence of a romantic relationship with Ms. Willis.
Fine, thank you, Your Honor. I understand. So going back to this line of inquiry, when you say you don't have personal knowledge, what I want to ask you to start with is very simple. Did you have communications with Mr. Wade about the relationship between Mr. Wade and Ms. Willis? It's a simple yes and no.
Yes.
Okay. And is it your testimony that during the time you were representing him, which I understood started sometime in 2018, is that correct?
That's the time frame that I remember, yes.
Is it your testimony under oath that with regards to conversations with Mr. Wade about his relationship with Ms. Willis, that you only had one such conversation during the time you represented Mr. Wade?
One conversation of what? I apologize.
The
It
only thing
broke up.
the only thing I'm asking about is that area that the court said is not privileged, which is the relationship between Mr. Wade and Ms. Willis. You've testified that during the time you represented Mr. Wade from 2018 on, that you only had one conversation with him in reference to the relationship between Ms. Willis and Mr. Wade. Is that correct?
Yeah, I think that's fairly accurate. Yes.
Okay, so out of the entire time, and talking about could be 2018, 2019, 2020, 2021, when did you stop representing Mr. Wade?
It was a few months after I left the firm.
All right, give me the approximate time.
I left maybe June, July of 2022, maybe.
Okay, so that would suggest that for, assuming it's 2018, 2019, 2020, 2021, and half of 2022, which is in the vicinity of 4 to 4.5 years, you're testifying under oath you had one conversation about a relationship between Mr. Wade and Ms. Willis. Is that correct?
I don't recall having any other conversation with Mr. Wade about him and Miss Willis.
Is it your testimony then that you don't remember any other conversation, or there wasn't any other conversation besides the one?
An object is to ask and answer.
I think he's drilling down. I think that's a fair question, overruled.
I don't recall. I would say it was the one, but I don't recall.
You testified that you did have communications with Mr. Wade about him visiting with Miss Willis at a condo or apartment, correct?
I don't think I testified that I had a conversation. I testified that any knowledge that I would have known anything about any condo would have come from that, but I don't recall a conversation about that. I do not recall a conversation about that.
Do you recall any other thing at this point in time under oath that would indicate when the relationship started between Mr. Wade and Miss Willis?
I do not know when the relationship started between Mr. Wade and Miss Willis. I cannot
So I'm
recall
gonna
that. I can't. Oh, I'm sorry. Go ahead.
I'm going to drill down on that now, okay?
Yes, sir.
Mr. Wade was hired as the special prosecutor on November 1st of 2021. You're aware of that, correct?
I have my contracts to show when I started. No one showed me the contract of when he started, but but if he has a contract for November 1st of 2021, then that's correct.
I'm going to suggest to you that the record will reflect that the contract between Miss Willis and Mr. Wade was November 1st of 2021, correct? I want you just to accept that, okay? Is it your testimony that you don't know under oath whether or not there was a relationship between Mr. Wade and Miss Willis before the contract?
I do not recall any dates of when the relationship started. So whether you are pinpointing a date of when his contract started or not, I'm telling you, I did not recall any specific date that he flat out said anything about a relationship with Miss Willis.
Okay. Now I want to go, based on what you've just said, let's go to what was Defense Exhibit 26. Okay? In Defense Exhibit 26, which I showed you last time, was 2 pages of text messages between you and Miss Merchant, correct?
Correct.
All right. Now, the first page starts off by saying, Miss Merchant, like just date, don't hire him. Do you think it started before she hired him? You see that?
Yes, I see it. Yes.
And your response to that was absolutely, correct?
I'm going to object, asked and answered in cumulative.
All right. So, Mr. Sadow, I do think we went through a lot of these texts.
We didn't go through this whole one.
Just a second, Mr. Sadow. All right. I'm sorry, Mr. Sadow. Well, you said we didn't go through this particular one?
No, we stopped right there. I want to go.
No, I answered because this is the exact language that she just stated a few minutes ago. You can read it back.
Okay, Mr.
In the
Sadow.
record.
Are you saying both of these 2 exhibits weren't already covered by Ms. Merchant?
It was not gone, this particular language was not gone into. I'm doing it based on the exhibit itself. Well, let's do it this way. I now move into evidence defense exhibit number 26.
All right, and I'd have to search through my notes, but does anyone recall that one actually been tendered in a minute already?
No, it was only presented to your honor for you to take back into camera ex parte to speak with Mr. Bradley and his counsel.
Okay, Ms. Merchant is indicating that it was admitted.
I thought Mr. Sadow admitted it, but I'm organizing and putting them back in order. So I think it might be easier if I just admit the copies of the
All right.
we're all referring to.
All right, so Defense Exhibit 26 and 27 are being tendered.
Well, actually, only 26 at this time.
Excuse me. Okay, Defense Exhibit 6, any objection from the state?
26.
26.
I'm going to object as it relates to foundation and authentication. It was used to, during the last hearing for the purposes of refreshing his recollection. And it's my recollection is that it didn't refresh his recollection, but I would renew my objection as to asked and answered in cumulative.
Okay. As to foundation and authentication, I think Mr. Bradley has recognized them as texts that he sent and received. So I think I'd overrule on that basis. Any other objections to their admissibility from any other defense counsel? And seeing none, Defense Exhibit 26 is now admitted. Mr. Sadow.
Thank you. All right, let's continue. Now I'm publishing it. After you said the word absolutely, on your own, you said it started when she left the DA's office and was judge in South Fulton. They met at.
Check.
Yeah.
Asked and answered.
All right, understood, Mr. Vadi. I'm going to let Mr. Sato have a few minutes on this, and we'll go from there. But
Judge, well, I'm sorry. I did answer this. I answered it for Ms.
understood.
Merchant. I stated that I was speculating. The judge, someone objected to the speculation, but this was the exact same language.
All right, well, thank you
when
for
I
that
said
recap,
that I
Mr. Bradley. Mr. Sato was
speculate.
asking the question in a slightly different manner, and I'm going to give him a little bit of leeway to do that. So, Mr. Sato.
All right, I hesitate to have to start back where I was, but after the word absolutely, you on your own said it started when she left the DA's office and was judge in South Fulton. They met at the municipal court CLE conference. That's what you said, correct?
That is correct.
Now, it's your testimony, at least so far, that when you on your own gave those two statements in the text, that you were merely speculating and did not have that knowledge from Mr. Wade. Is that your testimony under oath?
Yes, that's what I testified to. Yes, sir.
So you on your own came up with the whole notion that it started when she left the DA's office and was judge in South Fulton. That's, according to you, that's speculation on your part, correct?
Objection. Asked and
Overruled.
answered.
Answer the question, Mr. Bradley.
Yes, that's speculation on my part. Yes.
Right. It had nothing to do with what Mr. Wade had told you, correct?
I answered your question. I was speculating to the answer. That is correct.
So maybe you can tell the court in your own words, why in the heck would you speculate in this text message and say that it started when she left the DA's office and was a judge in South Fulton? Why would you speculate and say that in a text?
I knew they had met at the municipal court conference.
How do you know that? I'll stop you right there. How did you know that?
I answered that at the last.
I'm asking
I knew
you
that.
now.
I knew
Sir,
that
I'm
because
asking
when
you I'm asking you questions, and you are in a situation where you get to give answers. I'm
Mhm.
asking you, how did you know that?
how did I know
Somebody
when they
told-
met?
Somebody told you that, right?
When they met?
Yeah.
Yes, correct.
Who told you?
Mr. Wade told me when they met.
So you had more than one conversation about the relationship between Mr. Wade and Miss Willis because he told you where he met her,
That's
correct?
incorrect. Incorrect.
It's incorrect.
It's incorrect.
Let's go back
He-
to the exhibit. Why would you speculate that that's when they started the relationship? What would cause you to put that down as speculation?
I don't recall, but why I thought that it started at that time. But I do recall that he only met her, and I testified to that he met her at that conference, which was in 2019.
You knew that Ashley Merchant represented a defendant in this case when you were text messaging with her, correct?
Yes, I did. Yes.
And you knew that the reason she was asking you questions about Mr. Wade was because she was trying to show when the relationship began, correct?
No, that's not
It's not. What's the
100%
beginning of the
correct.
text message?
Yes, but
Text
what messages were before this message, before she sent that?
I can't answer that question because I don't have them. All I have is what's in front of you. And it
Yes.
says that she says, do you think it started before she hired you? So you knew as the counsel for a defendant in this case, that Miss Merchant was asking you specifically about the knowledge that you had regarding the timing of the relationship between Wade and Miss Willis, correct?
I mean, based on this, yes, I see
And
what was asked.
And in response to that, you answered directly on your own what you now claim to be speculation, right?
That's correct.
So I ask you one more time before I move to the next part of this. Why would you speculate when she was asking you a direct question about when the relationship started?
I have no answer for that.
Except for the fact that you do in fact know when it started, and you don't want to testify to that in court. That's
Overruled.
the best explanation, isn't it?
This is a completely
Overruled.
argumentative.
That's the true explanation, because you don't want to admit it in court, correct?
No, I have no direct knowledge of when the relationship started.
I'm not going to go back through that again. But if you didn't know, and you were asked specifically as this exhibit shows,
Mhm.
maybe you can explain why you wouldn't say, I don't know.
Is that a question? You're
Oh,
asking me
yeah,
a question to
definite-
answer?
Definite question.
State that again. I apologize.
If you're being asked, as we've just gone through with this text message from Miss Merchant,
Yes.
as the attorney for a co-defendant,
Yes.
and she's asking you about the relationship, and she's clearly asking you about the timing, why wouldn't you just have said in response, I don't know when it started?
I don't know why I didn't say I don't know.
Maybe, again, it's because you know what the truth is, and that's why you answered exactly the way you did in Defense Exhibit 26, correct?
No, I can't sit here and tell you that what you just stated was correct.
Right. What you want the court to believe, and you want the rest of us to believe, is that for some unknown reason, upon being asked a direct question about when the relationship started, you decided on your own to simply speculate and put it down in a text message, as opposed to putting down what you actually knew. That's what you want the court to believe, correct?
That was a lot. So can you break that down? I apologize. You're asking me, do I want the court to
believe that instead of saying nothing, you decided on your own to speculate.
Yes, I speculated. Yes, I've stated that I speculated. Yes, sir.
Right. That's what you want the court to believe, correct?
That's correct.
Okay, now, then when you go to the next page of that, okay, you see it starts, the best that I can see, it starts in South Fulton. Is that what you have in front of you? Second page.
The second page that I have says, that's what I figured.
Okay, that may be cut off from the one that I have. I'm looking at my opening set line says in South Fulton. Is that on your second page?
No. So if you're going in order of the pages, no, neither page starts with South Fulton.
No, don't get caught up in whether it starts that way. Does the second page have a line in there that says in South Fulton?
Oh, yes, I apologize. So, yes.
That's fine.
Yes.
Just want to make sure that we're on the same page.
Yes.
Okay. You say after in South Fulton, they met at the municipal court CLE conference, right? You
Yes,
see that?
is good. Yes, that's correct.
And then Miss Merchant says, that's what I figured when he was married. Is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. You see, that's what she said, right?
No, I mean, so it says at municipal court CLE. The only other thing here says that's what I figured when he was married. There's no response for me. on that day. And then there's another response. I guess a question that says, is this accurate?
Okay, that's what I just went over with you.
Okay, so I don't have anything in that. Is this accurate at all? I can show the
No.
court. It's just,
Okay.
it just says, is this accurate with the question mark? I don't have anything following that.
You don't have, after that, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship.
Yeah,
at that
okay, it's, I apologize. It goes to the next page. I apologize.
No problem. Just want to make
Yeah.
sure that
But no, I see that now, yes.
All right. So that's what I just read is
Mhm.
exactly what Ms. Merchant said to you in the text, right?
Yes, that was in the text. Is it accurate upon further information? Yes, that's there,
And-
yes.
Again, since you have told us that you were speculating when you gave the answer that we went over with previously, on this one, you don't say, I don't know. You simply correct her by saying no, municipal court, right?
Yes, so she asked, was it accurate? And I said it wasn't accurate. No, it wasn't accurate. It was municipal court.
Right. And when you said it wasn't accurate, it was municipal court, didn't say, no, that's not accurate. They didn't start a romantic relationship at that time, correct?
No, but I was referring to the municipal court. No, it wasn't accurate as it applied to I was answering the no municipal court, meaning when she said, is that accurate? It was to the municipal court and not magistrate court.
Okay. But you didn't say that the rest of what she asked you was accurate. You didn't say, no, that's inaccurate. That's not true. That's not accurate. You simply said the only thing that wasn't accurate was municipal court should be there instead of magistrate, right?
So I was answering the question of, it was a compound question.
Can you
And I was answering the question of, she
There's
wrote
no-
magistrate court and I said, no, municipal court.
Right, but it's not compound. It's one statement upon
Mr. Sadow.
information and belief. I'm sorry.
No, that's okay. I know the feedback and the delay is complicates things, but I think you've adequately made your point here. I don't think we need to belabor it much longer. Let's move on to the next issue.
Okay, thank you, Your Honor. Mr. Bradley, prior to coming into court today, did you and your lawyer meet with anyone from the district attorney's office?
No. I mean,
Sure.
no, not that I know, I'm aware of, no.
Have you
I
had
did not
any?
meet to anyone.
I'm sorry, I
I
cut
did
you
not
off.
meet with anyone outside of my attorneys.
Did you have any conversation? Not
I did
meeting,
not.
conversation.
I did not.
So you have not spoken, if I understand you correctly, prior to coming into court today, you've not spoken with the prosecutors,
No.
right?
I've not spoken to the prosecutors. I've not spoken to defense.
Have you spoken to Mr. Wade?
No.
So as far as just getting into the courtroom today, there's been no contact or conversation in it with any of the parties we just went over, right?
There has not been any contact with defense or the state at all.
I think I have basically just one or two more questions. Why would you see the need to speculate when you were texting with Miss Merchant?
I think we did cover that one, Mr. Sadow. I think that exact question was already put to him. What would be the next one?
I'm trying to look. Let's go to 27. Defense Exhibit 27. Do you have that now, sir?
I do, sir.
All right. Would you look at it and tell me whether or not the Defense Exhibit 27 appears to be accurate? Because I want to seek to introduce it into evidence. It consists of an email to you from Miss Merchant and a text response from you, correct?
But the text response was not in response. So yes, it does consist of the email and a text response. I'm not saying that the text response applies to the entire email that was sent.
All I've asked you right now is, is the
Yes,
email and the text, are those accurate in the interaction that makes up Defense Exhibit 27?
as it applies to the stapling of the email and the stapling of a text message chain, yes, that is Defendant's Exhibit 27. This is, it's accurate.
Okay, I would move Defense Exhibit 27 in. I believe it was treated the same way as 26 last time, Your Honor.
Same objections, Mr. Abadi?
Yes, Judge.
All right, overruled. Any other objections from defense counsel? Seeing none, defendant's exhibit 27 is admitted.
And,
Anything
Your Honor,
else,
I don't
Mr.
know.
Sato?
Yeah, I don't know whether you'll find this objectionable or not. I'll ask it, and obviously.
All right.
Mr. Bradley, you realize that if you were to testify under oath, that you knew from Mr. Wade that the relationship between him and Miss Willis existed before the contract in November 1st of 2021, that if you testified that you knew that from Mr. Wade, that would show that both Miss Willis and Mr. Wade had lied under oath. You know that, don't you?
Yeah,
I'm gonna object.
I think that's going to call for an opinion on the credibility of another testifying witness. So I don't think that would be an appropriate question.
Then that's all I have, Your Honor.
Thank you, Mr. Sato. Mr. Stockton,
Just briefly, Judge.
we'll see.
Mr. Bradley, do I understand from your prior testimony that Ms. Merchant sent you a motion to review prior to her filing it?
Objection. Calls for cumulative answers.
Right. I'm going to give him just a little bit. All right, Mr. Stockton, maybe this is going somewhere else.
Did Mrs. Merchant send you a motion prior to January 8th of 2024 for you to review?
That is correct.
And did you in fact review that motion?
That is correct.
And did you indicate to Ms. Merchant that the contents of that motion seemed okay to you?
Well, so you're referring to Exhibit 27, which, as I stated a few minutes ago, one is an email, one is a text chain. So in the text chain, when I never responded to the email, I never responded looks good or anything to the email that was sent to me. However, in the text chain, what you all are trying to merge together is the fact that I was asked about the contract, and that contract was $74,000, and me being added back to that. So when I said, and I think before that in that text, it referred to me being added back, and at that time I said yes, looks good.
And you're aware and you recall that when Ms. Merchant presented you with that motion, she asked you not to disclose it to anyone until she filed it. Is that correct?
We are covering, I think, the last 5 or 6 questions. We've covered ground. Let's get to that ultimate point.
I'm trying to get there,
All
Judge, I
right.
promise you.
Okay.
Repeat the question, I'm sorry.
She asked you not to disclose that motion to anybody until she filed it, correct?
I think so. I think that was in the text message, yes.
And you knew, in fact, it was her intention to file that motion, correct?
The actual motion that she, that was sent,
Yes.
I knew that she was going to file a motion, yes. I do not think that that was the final draft, or it could have been that she was working on it, but yes, I knew that she was going to file some motion, yes.
And you knew that she presented that motion to you for your review so that she could make sure it was accurate, correct?
Your Honor, I'm going to object. All this is asked and answered and cumulative. given.
All right, noted. I think Mr. Stockton's getting to the next point. So why don't we just ask that one?
Is that correct?
Did you
Why
know
don't
that?
we
I thought
why don't we
you,
combine that with the next question, so we're not having to lay bit by bit every single time.
Mr. Bradley, you knew that Mrs. Merchant was relying on your review to ensure the accuracy of that motion prior to filing it, correct?
Speculation as to what he knew that Miss Merchant knew.
No,
Gonna do.
I'd overrule that. Mr. Bradley?
no, so once again, I was excluded from the footnote of that motion. And my review of it, and I said, hey, you need to add me back to the footnote because I did have a contract and I did receive 74,000.
And if I may help you out, let's talk just about that part of the motion that deals with the relationship between the District Attorney Willis
Mhm.
and Mr. Wade.
Mhm.
When you reviewed that, you knew that that Ms.
No.
Merchant,
No, I did not know that she was relying on me for any relying on me for any accuracy other than what was put in there
if there
about the
was,
74,000.
Mr. Bradley, if there was something patently false in that motion, you would have told Ms. Merchant, wouldn't you?
I can't say that I would or wouldn't have. I don't know what I would have told Mr. Merchant.
If there was something patently speculative, you would have told Ms. Merchant, wouldn't you?
I don't know what I would have told Ms. Merchant. She asked me, was it accurate? We were discussing the 74,000 that was left out.
Again, if I may direct you just to that portion dealing with the relationship between Mrs. Willis and Mr. Wade. You didn't tell her that there was anything patently false in that because you didn't see anything patently false in that motion as it relates to the relationship.
Repeat your question. I'm so sorry.
You did not inform Mrs. Merchant that there was anything patently false in that motion that you were presented with as it concerns the relationship because you did not see anything that was patently false, correct?
Objection asked and answered cumulative.
All right, next question, Mr. Stockton. Sustained.
And you didn't see anything that was speculative in there
All right.
either, did you?
Asked and answered
I
cumulative.
know, sustained, Mr. Stockton.
I just want to ask you one more question. I'm coming at from the other way that Mr. Sadow did. Did anybody from the district attorney's office or any witnesses in this case contact you about Ms. Merchant's motion from January the 8th of 2004 until today?
Did anyone contact me about her motion?
Yes, from the district attorney's office or any witnesses or anybody else involved with the case besides the defense?
Other than the call the only personal call that I had was with Gabe Banks. I never spoke to anyone else, and to my knowledge, he's not a part of this. So
That's all I got, Judge.
Thank you, Mr. Stockton. Mr. Durham, if you're still with us.
No questions, Your Honor.
Thank you, sir. Mr. McDougall.
Good afternoon, Mr. Bradley. You have certain information about the relationship between Mr. Wade and Ms. Willis that is not privileged, correct?
Well, that was my determination, so I think he disagrees with it. So what we're going to say his opinion's a little irrelevant on that point.
Do you understand that the court has ruled that certain information that you have about the relationship between Ms. Willis and Mr. Wade is not privileged?
I have the court's ruling, as I understood it, and as my lawyers and I understood it, of the privilege not existing was based off of a conversation that was had in my office, in the back of my office, which was confidential, with Mr. Wade and I. That's what was asked of me on yesterday, and that's what the ruling, to my knowledge, unless I'm being corrected here now and saying that it's more, it was that particular piece that the judge said did not have privilege.
And have you testified already today to the sum total of your knowledge of the relationship that is outside the scope of the privilege according to the court's ruling?
Can you ask that again? I'm sorry, I didn't understand it.
Referring to what you understand to be the information that is not privileged, have you testified to the sum total of that information?
I think I have, yes. I think I've testified to that, yes.
All right, sir. That's my questions.
Thank you, Mr. McDougal. Mr. Rice.
Mr. Bradley, at least as of February 15th, when you first testified, you said that you still considered yourself a friend with Mr. Wade, correct?
I think I said that, yes. I think I did, yes.
And you've been friends with Mr. Wade for over 10 years, correct?
That would have been fairly accurate, yes.
And you recall communicating with Ms. Merchant about this case and about Mr. Wade and Ms. Willis's relationship, correct?
And object as to asked and answered and cumulative by all three of the previous.
Sure. We don't lay that foundation. Why don't we combine it with the next question where you've got a new point to make?
Mr. Bradley, when you communicated with Ms. Merchant, did you tell her any lies about Mr. Wade and Ms. Willis's relationship?
Did I lie to Miss?
That's a simple question, Mr. Bradley. You're a lawyer. Did you lie to Ms. Merchant when you told her facts about Mr. Wade and Ms. Willis's relationship?
Not that I recall. I don't recall. I mentioned earlier that I speculated on some things. I've testified to what I did know. So I can't recall whether or not no.
Mr. Bradley, speculation is kind of a weaselly lawyer word. Let's speak truth here.
Then
You're under oath.
to argumentative at this point, Your Honor. It's not asking relevant questions.
Mr. Bradley.
Find a question, Mr. Rice.
Mr. Bradley, when you were communicating different details of the relationship between Miss Willis and Mr. Wade to Mrs. Merchant, did you lie to her about any of those details?
Objection asked and answered twice.
I don't think he's answered it yet.
I don't recall ever whether any of it was a lie or not
Well,
at this time. So
at the time you were communicating with Miss Merchant, you were still friends with Mr. Wade, correct?
yes,
And at the time you were communicating with Miss Merchant, you knew that she was talking to you in her role and capacity as an attorney in this case, correct?
correct.
And you knew that she was going to use that information to somehow benefit and file a motion, benefit her client, correct?
I did not know that.
Okay,
So
see,
I did not. Oh, I'm sorry.
so as an attorney yourself, you are testifying here under oath that you had no idea what Miss Merchant was going to do with all the details that you were giving her about Wade and Willis's relationship.
So at the time, no, I did not. I knew that Miss Merchant was gathering information. That is correct.
And Did you lie to her when you told her that the relationship began
All right.
before 2020?
I don't think we need to drill into specifics. He's covered it at a high level. I don't think we're going to get much out of this.
Mr. Bradley, isn't it true the only thing that has really changed? Well, you were speaking to Miss Merchant, whether by text or by telephone. You never said to her that I don't remember or that I'm speculating, correct?
I don't recall.
Well, you've looked through a whole lot of text messages. Do you remember ever seeing any communication from you that said, I don't remember?
Yeah, through the messages that I don't have all the messages in front of me, but no, I don't recall if I ever said I don't remember.
Do you recall seeing any text messages where you replied to her or gave her details where you said, I am speculating about this detail?
No, I never used the word speculating. No.
And the only thing that's changed between then and now is that phone call from Nathan Wade's friend, Grave Banks, correct?
No, well, Gabe was my friend, and I actually stated that the first day that I was here was that I've known Gabe for a few years, and that we were we are fraternity brothers, and so I never said that that anything changed behind Gabe Banks.
So you never told Miss Merchant that you were worried that they were threatening you?
Objection, asked and answered when he was asked this on February 16th and today.
Mr. Rice, we've covered this.
And just to be clear, you didn't attend college with Mr. Banks, did you?
I did not attend college with Mr. Banks.
When you referred to him as your fraternity brother, y'all just both happened to have pledged the same fraternity, different colleges, different chapters.
Well, that's what we consider fraternity brothers, yes, sir.
And as a normal course of your relationships with your friends, do you pass on lies about your friends?
Have I passed on a lie about a friend? Is that what you're asking?
Is that something you normally do, Mr. Bradley? Do you tell lies about your friends?
Have I told lies about friends? I could have, I don't know.
Do you tell lies about your friends about a case of national importance?
Objection, as to
All right, overruled.
I could have, I don't know.
Mr. Bradley, I notice you're not looking at me.
I'm looking at you on the screen only because I was accused of, and I did the same thing to Mr. Sadow when he was on the
What's
screen.
the next question, Mr. Rice?
No further questions, Judge. I think it's clear.
Thank you, sir. Mr. Gillum.
Good afternoon, Mr. Bradley. A few questions. A lot of folks have taken up the questions that I wanted to ask, but I've got a few left here.
We'll see.
We'll see. You said Mr. Bradley, you said you didn't know what Ms. Merchant was going to be doing with the motion that she sent you. You remember that testimony a few minutes ago?
I think I said I didn't know that. I knew that she was gathering information, yes.
Well, let's look at the title of the motion that she sent you. Do you remember
That was
reading?
sent on the 6th.
Excuse me. Do you remember reading the defendant Michael Roman's motion to dismiss grand jury indictment as fatally defective and motion to disqualify the district attorney, her office, and the special prosecutor from further prosecuting this matter? Do you remember seeing that in the draft that you read and reviewed?
Yes.
So when you tell this court that you didn't know what she was what she was going to do, she kind of gave you a hint, didn't she, in the title of the motion that she sent for you to read? Didn't she? Yes or no?
I read the title of what the motion was.
And there wasn't anything in the title that threw you off. Pretty straightforward speaking title, isn't it?
Correct.
So you knew that what she wanted was information from you so that she could then file a motion to dismiss the grand jury indictment to motion to disqualify the district attorney and her office and the special prosecutor from further prosecuting the matter, right?
I'm gonna object to speculation.
You knew that, didn't you?
Overruled.
Yes or no?
When she sent that motion, yes.
Okay. And you knew that the special prosecutor that to whom she was referring in that motion was Mr. Wade, correct? You knew that
Yes.
because you read the motion. You said you reviewed it, correct?
Yes.
And we're not going to go over all of the, number one, because we don't have time, and number two, the court wouldn't let me. But but there are a few things that I do want to ask you about in that response, in that aspect. Now, in that motion that you said you reviewed, on page 6 of that motion, well, on page 5, it starts off with, how do we know this? And there's a question mark.
All right.
Hearsay.
Yeah, Mr. Gillen, I can appreciate what you're doing. I think that's something you can do at argument. He's said as a whole that he got the motion and he's had his response as to his opinion of how he handled it. I don't see that, again, this really being necessary to go through it line by line of what.
Well, a little indulgence, Your Honor. I'm not going to go, this isn't going to be a 40-minute death march through the motion. I would like to ask about a few bullet points that capture under this, and then I'll move on. But I would ask the court's indulgence in that respect.
Again, I think we've covered it, and I think that you'll be able to argue that this was in that motion and that he had a chance to review it, and he never objected to anything in there or raised it. So
That's a problem, and always ending up last.
it very much is. And next time asked, I'll reshuffle the order.
Well, we did earlier with Mr. Wade, and then
I hear you.
That was kind enough, and
I hear
then
you.
the court said we had to go.
You'll need to draw straws next time.
There we go. I'll go with that.
All right. Anything
Thank you, Your
else?
Honor. That's all I have.
Okay. We had Mr. Kucherov potentially still on Zoom.
Yes, Your Honor, and I have just a few questions.
All right. Could we add a spotlight to Mr. Kucherov? I'll let you know when we're able to proceed.
Judge, before he starts, can I take a 5-minute restroom? It's
Absolutely.
been 2 hours.
Yeah, we've been going 2 hours. So let's come back at 4 o'clock. I'll also note for the record that we received a notification from Mr. Cromwell on behalf of Ms. Latham, and he said he was waiving her presence. And I don't know if he later decided to join us by Zoom, but I don't think he was electing to log in. So after Mr. Kucherov, just in terms of timing, Mr. Abadi, do you have any expectation of how long your, if any, questioning would last?
I don't imagine my questioning would be very long.
Okay, well, let's get back in at 4 o'clock. Mr. Bradley, you can just step out of the jury room.
Hey, Judge. Wait, why can't I hear you? Oh, I can't. Do you have? You gotta connect. Oh, all right. Wait, you just left out. So let me hang up the phone and you just come.
Didn't do anything.
All right, so I'm gonna hang up the phone and just click the StreamYard again.
Okay.
All right, guys. So we will resume back when they come back from break, but the judge is coming up and he is going to make some comments about, because he's been listening backstage. So he's going to come up and give some commentary about what has been said so far. And also, let me see if I could add this. Where is, oh God, I thought I had that already. Some Fani paperwork here. Let's see if I could. Okay. There you go.
Let me get a better background instead of this. Hold on. Let me see. Does this work better out here for a change?
Okay, you're outside. I was trying to
It
bring.
works out here.
So what so far on this? Hold on, I could do it. Can you hear me?
All right, how's this?
Oh yeah, that's I like. What room is that?
Is okay?
I love that room. What room is that?
Hello?
Can you hear me?
Hello?
Oh my God, now he can't hear. Can you hear me? Okay, you can't hear me. Tess, now you're muted. Unmute. Unmute yourself. Unmute.
Hello?
Yeah, can you hear me? Can you hear me? All right, wait a minute. Yeah, I can hear you, but you can't hear me online. So it's something with the headphones you got on. It's not connecting to the StreamYard. You gotta connect those headphones to the StreamYard.
I am. I thought I was not dialing you on the phone.
No, you
on StreamYard. Here, I'll go back and come out again.
okay. All right, he's gonna go back. I know we could hear the judge, but he couldn't hear me for some reason. That was the problem. What is this here? All right, wait a minute. So he's going to come back in. What is this? Oh, is it this? Great. Keep both. I don't know. All right, just give the judge a minute. He's going to come back in. Oh, are those headphones you don't? Yes. Jaren, yes. Those are the headphones I don't like. I can't stand those headphones. Yes. So before they come back from break, I want the judge to come up and give his commentary because he has to go and shoot a movie like at 4:30. So and it's for his time. So it's 3:00 his time, 4:00 my time right now. Okay, there you go. Can you hear me?
I hear you loud and clear.
Okay, good. All right. So what are your thoughts so far?
Well, aside from some of the lawyers being very clumsy with their inartful cross-examination, I see a bunch of corporate lawyers who haven't had a whole lot of criminal trial experience. But that said, the witness they're examining is an attorney who appears to have some trial experience himself, so their style is backfiring. They should treat him as a friendly witness instead of trying to intimidate him, which is not going to happen. The judge is impressing me immensely. He is giving a textbook demonstration of how it's supposed to be done. I applaud him. That is quite at a contrast with some of the rather poor performances that I've observed in some recent televised court proceedings. He's using the artful method of saying, I don't remember, I do not recall. The other things going on is these are text exchanges. These are not documents that someone pores over and corrects again and again to get them pristinely perfect or as best as one can get them. This is text, and it's kind of sort of like, think about when you do text, things you might overlook because you're doing it quickly. The use of language is not always precise, text or by voice, and lawyers themselves are showing how imprecise language can be. Some of them are fumbling and stumbling very badly. So where do we go with this? As the judge pointed out just recently, it's a matter of argument. So we have evidence in here. We have questions that have been asked multiple times, answers given on multiple occasions during the course of these proceedings and in slightly varying fashions. The court is going to make up its mind. And before it does, you can argue to the court what effect this evidence is supposed to have. So that's where we are, and I think each of them is trying to earn their fees. A couple of them have said we have no questions, which is about where it is right now, because as the judge pointed out, these are matters for argument. So,
Right.
yeah.
So, all right. Also, what I wanted to bring up, because you're going to be picked up at 4:30 your time. That's like in another hour and a half. You text me this.
Oh, yeah, the filing with the Georgia Ethics Committee. And the complaint that's reflected is someone is complaining about the lack of ethics in Miss Fani Willis's compliance with the election finance reporting laws. So she'll have to answer that, because you see, when you're talking about a bar, you're talking about practicing law or being a judge, is also a character element that has to be complied with. And what they're arguing is, well, not arguing, but what they're demanding be shown is that you are being an ethical person of good character. And if you have broken the law, infracted any regulations, then you're going to have to answer to that. So it's not a Fifth Amendment situation. You can take it, but if you do, you will probably run into a big problem when it comes to keeping your license to practice law.
So this was issued.
So this document, in essence, cites what she's being required to answer to. It gives her 30 days to reply. They indicate they will make a determination as to whether there's nothing about it or if there is something to it, and she's going to have to answer further.
And this came about.
That's what we have. It's one of several I anticipate you'll probably get.
Mhm.
And as I have remarked in the past discussing this particular matter, when Miss Fani got up and arrogantly took the stand and chatted, she should have kept in mind, since she is the DA, you have a right to remain silent. Anything you say can and may be used in evidence against you, but she kept offering things. So it's a literal can of worms, and worm heads are going to start peeking up outside of the can for a while now.
All right. Can you hear me?
Bad move.
Can you hear me?
You've got tax problems.
Oh, you
You've
can't
got
hear me.
failure to report as required by election law in Georgia. And remember, she's supposed to be on top of that, because what she's doing? She's prosecuting somebody for violating Georgia's election laws. Also, the laundering money and all that kind of stuff, she opened the door to that. cash payments. She opened the door to that, and cash payments are supposed to be receipted and documented. And she's testifying to large cash transactions that were not receipted nor reported. She's talking about the consequences of her okaying expense claims, which are pretty high and, in my opinion, rather excessive. So are state money for their own benefit in a fashion that has not been earned, or what are they doing?
Can you hear me?
So one of the things, by the way, that is going on here is questions are being asked that if you miss, you have missed anything. Because as has been pointed out over and over again, question or that avenue of inquiry, it's been inquired into, question has been asked, and the question has been answered. The judge is giving them leeway, a great deal of leeway,
to you, to your office,
develop a line of inquiry, but they aren't really doing anything with it. The court's
so
been
you didn't
quite
talk with him that whole
indulgent,
time?
and he's been playing it straight up and down.
I left in
neutral.
2022. I haven't really spoke to him since 2022
So-
is what I stated. When I left June of 2022, around June, August dates of 2022.
Other than your, one last question, other than your attorney, who did you speak with today about giving testimony in this case today?
I spoke to my attorneys, Charles Graham and BC Chopra.
I have nothing further, Your Honor.
All right. And again, I'll just double check to make sure. Did Mr. Cromwell ever join us by Zoom? Do we?
He's still having technical issues.
Okay.
He did email me saying he has no questions. It appears that all relevant questions were asked.
All right, thank you. So just for the record, Mr. Cromwell has been apparently watching the proceeding. He had waived his client's presence and didn't have any other questions as well. So turning it over to Mr. Abadi.
And I have no questions.
All right. Mr. Bradley, you can step down. Thank you, sir.
Judge, you want these exhibits?
I'll take this one. Good night.
May I
All
be
right.
excused?
That's right.
I have a follow-up based on some questions, and it's just about the text.
And what, just by way of proffer, what about the text?
Just to admit, so when other people asked about the text, some of them weren't in the record today, so I organized them. They're the ones that have been talked about today, so I just organized them. I just wanted for point of reference to have them. That's
Okay.
it.
Okay. And do we need Mr. Bradley for that?
I don't believe so, but
Have you marked them?
yes,
Have you showed them to the state?
I gave a copy to the state, but so these
Mr.
are.
Bradley, just hang on just for 1 second, just to make sure.
I'll give you all of them.
Admitting all of them?
Yeah, Judge, go back out and
Okay.
come back in.
If you want.
I'm not objecting.
And I
Now
think
we
this
can't
is
hear
like-
you.
And while he's looking at that, Mr. Bradley handed me Defense Exhibit 23, 24, 25.
Judge, I didn't realize that they were
This-
in my folder.
Oh, is that from the hearing?
That it
From on
was
Friday?
here, so-
All right, well, thanks for returning those.
Fine, if you want that
Uh,
out. The reason that goes in is because you.
Let me make sure.
As long as you admit it.
Because of your objections, front part and the back part of this. You have an objection to any of them, you can tell me, or you can admit.
Okay, so I've got 23, 24, 25. Anything else in your binder? All right, good. Okay, and have we come to any conclusions on, what, I'm sorry, how did you mark it?
I think we're up to 39. Surprisingly, the state objects.
All right, Defense Exhibit 39 is tendered and admitted without objection.
Well, no.
Oh, I'm sorry. Oh, okay,
Text messages that weren't referenced today with, or confronted, with,
okay.
as it relates to Mr. Bradley.
So these are additional text messages, Ms. Merchant?
Yeah, so what I did was they objected that they weren't complete because like the first part of the text wasn't there. It was just like, oh, there was something before that was said. So what I did was I spent this whole time trying to line them up so that I had the beginning of the text, the middle, based on their objection. They have all the text. They can admit all of them if they want them complete. And
All right, how about, I'll just do this. Just, I understand the desire just to have the complete text chain, just for purposes of completing the record. You know, I think that there's no point in having him sit here and authenticate every single one of them. So I'm willing to admit it as a court's exhibit. And only the exhibits, though, that had been previously tendered or referenced in testimony would be ones that actually are relied on for making any findings. But just so it's on the record, we have the complete text change, should that ever be an issue for some reason. Any thoughts about that, Mr. Abadi?
My only thoughts are this is not the complete text chain. I'd look
Yeah.
to briefly look at Miss Merchant's phone when she allowed us to have it for
Okay.
seconds, minutes, and there are text messages I know that I saw that are not in what is purported to be State's Exhibit 39. So
Okay.
it's not
All right.
complete
Miss
text.
Merchant, what about that?
I let them take screenshots of the ones that they thought weren't there, and he sent them to himself on my phone. I have also offered to hook my phone up to whatever it is. My phone's an iPhone, his is an Android. I can't download like you could in a normal text. I told them if they had a system to get all of my texts, they can have every single one of them.
We can definitely do that.
Your Honor,
Yeah, Mr. Rice.
text that she's submitting now and tendering into evidence, they are specific parts of the conversation. The entire text chain isn't a continuous conversation subject to Rule 601. Those particular parts, given the witness's testimony, should be admitted as substantive evidence to fire inconsistent statements with this testimony today. It would be up to the government, the state, if they then want to introduce the rest of it, have at it.
Yeah. Sure. I think that's a fair point that if he had been confronted with a particular text, that could have been the opportunity to admit it as a prior inconsistent statement for impeachment. And some of them were, but apparently some of them were not.
I'm taking those out. So I'm taking out the ones that they said he wasn't confronted with, and I'm just going to admit the ones that he was confronted with. That's fine. It just makes it more confusing, but it's fine.
All right. So we have a newly marked, newly compiled 39. Let's see what the state thinks of that one.
You know what the solution is? To admit both. List
All right.
of
Regardless,
what
if
actually
that's now
was
what
examined
discussed. Again, I don't see.
and the totality of the chain.
Can you hear me now?
I hear you.
Take care.
I'm just saying the dilemma here, that nobody seems to have come up with, is you have two things. One, admit the whole thing, everything is a proffer. And then you have one agreed upon by all parties that touch upon those things he was cross-examined upon or was asked questions about, in other words. This is everything with the text chain. These are the items that he was asked questions about.
Okay. All right. So,
If I were the judge, I would have it entered that way, but it's him. He's going to make the decision. That might raise difficulties on an appellate record, but maybe not. But I would not take any chances if I was defense counsel, and I would make that request.
But you didn't confront him with them.
When Ms. Cross had met the witness.
Yeah.
I did that one.
Okay. Anything else?
Okay, so
So where
Hello?
are we with Defense Exhibit 39?
Can't hear you.
might be helpful. if
Can you hear
looked
me?
at them so you know what we're talking about, but I confronted him with all of these.
can you hear
Right,
me?
I know. So
Oh, you're.
Exhibit 26, I put in so that it.
Can you hear me?
could read it. You know, when you're reading a text and it's a conversation,
Sure.
they're upset that they're not in order now, I guess. I don't really understand, but if you want to look at them, you can.
Well, let's start from the beginning. What is the purpose of Defense Exhibit 39?
Hello?
Ones that I showed him.
Yeah.
and
Okay,
that
can
I
you
showed
hear
him
me?
today. So there were a lot of follow-up questions on it, and so I realized,
Can
okay,
you
well,
hear
they should
me?
just be in the record.
Can you hear me?
Other people are referring to my texts, and
I can hear you, but can you hear me? You can't hear me. It's like it goes in and out. It goes in and out. I don't know. Just take that off. Can you hear me now? Can you hear me?
Hello?
Yeah, he can't hear me. He can't hear me. Yeah. Yeah, you can't. For some reason, you hear me in the beginning, but you can't continue to hear me through the headsets on a live stream for some reason. So just click on it with your phone without you don't need the headphones to hear the courtroom.
Well, I'm getting an echo. I'm on my phone without the earphone.
Yeah, just don't don't hook up the earphones to your phone because it's you.
But I'm getting a bad echo.
Yeah, because I have you on here now. Wait, so go out and come back in, but don't come back in with the headphones. Just come back in on your phone.
You're breaking up then.
All right.
So, okay, let me see what's going on.
All right, drop out and come back in on your phone and come back in again on the StreamYard without the headphones.
Okay, hang up the phone and see what
Okay.
we have.
Hello? Now I can't hear you. Just drop out. Just drop down. Drop down and come back in. Can't hear you. All right, he's going to come back in.
We don't have the full chain. The full chain is text messages that begin in September and continue down. That's not containing that
we do
entire
need a little
package.
flip
They're on her
side.
phone.
Okay.
She'd like us to do it in
think that would help.
that's just that chain.
All right,
Have to do
Ms.
the
Merchant,
technology.
and then I'll, Mr. Gillum.
Not a problem. And I offered that when we were here before, and I was told they didn't have that technology. But let me just go through them one by one. It might be easier. I was trying to just do it quickly all
You can
together.
just hand them to me.
So the first.
Just hand them to me. I can read them. And and
I marked them all separately.
while I'm reading them, Mr. Gillen, what did you have to add?
3 point, Your Honor. Apparently, this merchant has allowed the state to take screenshots of what they now contend would be the larger perspective on, and I disagree with them about the rule of completeness, but it's their job when something is admitted, that if they have an objection because the context is not appropriate, they then move. And the state should move the rule of completeness, the admissibility of the other.
Can you hear me now?
emails,
I hear you. I could hear
they
you
had.
before.
So the real issue here is their failure to comply with the rule of completeness once they have the material from the last hearing that they took screenshots of.
Well, isn't that what he's doing now? Because now they're being tendered?
No, I don't think that he is. I mean, it seemed to me that what was happening here is this Ms. Merchant has tried several different ways to get it in. She wanted everything in and they objected to that. And she wanted the segments in that had been, the witness had been asked about, and that's what she's trying to do. My point is that if they're at the time of frankly, of moving under the rule of completeness is at the time of the tendering. If they want to tender something to show that it should be included to be complete, that's on them,
Sure.
not on this merchant.
All right, Mr. Abadi, last point here.
So I had a very limited time with Miss Merchant's cell phone. I only had time to literally find one part of the text message to then send to myself before Miss Merchant demanded her phone back. So I did not have the opportunity to screenshot every act or every missing part of the conversation to then do as Mr. Gillum is saying that should be done, but it can't be done if I don't have the information. So you don't have the complete packet, and there are many of the text message screenshots that you have printed out that were not used to confront Mr. Bradley or refresh his recollection. So they're inadmissible evidence. If anyone missed the opportunity, it was the defense counsel
Sure.
to confront him.
All right, I don't think we need to get back and forth any further. Ms. Merchant, you said to print out a complete chain of every text exchange with Mr. Bradley since you began corresponding with him. I'll give you the chance to do that, and you can follow up by email with that exhibit. It would be the complete chain without any deletions or removals, and we'll have that marked as Defense Exhibit 39.
And by the way, you will be getting paid several hundred, if not
Friday at 1:56.
thousands of dollars an hour
Mr. Abadi
to
texted himself the screenshots.
print that
I
out.
literally wrote him, do you want any other screenshots? I have nothing to hide. You can download my phone app. So
All right, we're done. Okay, so I'll wait back to hear from y'all on Exhibit 39. And is there anything else to take up before we discuss Friday? Just kind of throwing it open to the floor. Seeing none, I believe I'd asked and put it out there among defense counsel to be considering how they would like to organize their arguments on Friday. Has there been any decisions reached on that?
to determine that.
Okay.
And I can email the court when we're done with that, but we are going to make it as efficient as possible and break it up.
break it up in terms of like subject matter or something like that?
There's time limits.
Yeah.
That's large.
Yeah,
Let us know.
that's the idea.
You can tell us what that'll be, and then
Well, I'll start with, what is it that you're asking for? And we'll start there. It's kind of curious.
Well, I don't think
Yeah.
we can answer that right now. Number one, the court said, look, if you divide it up,
My
then
observation
we can
that
go
is,
with
why
that.
can't you draw it?
Or if you can't divide it
You
up,
have to
then
talk
I'll
to
give
15
each
people in your
defense
firm
counsel
to
a
figure it
specific
out.
period of time.
See, in a
Tomorrow,
lot
we'll
of
find
places,
out when we
and
meet
have as
whether or
crucial
not.
a set of issues as you have here, which really aren't that complex in the scheme of things. And you would go from this point right here into argument.
Mhm.
You wouldn't get Wednesday, Thursday, and then argue on Friday after you've had 2 days to compose yourself.
I think that the Trump lawyers, they're overdoing it. They're being
They're
too.
used to billable hours and they are billing.
Oh.
You know, if you can do something in 5 minutes, but you can stretch it out to take an hour instead of 5 minutes, which would be 1/12 of an hour, and 1/12 of your billing hour, hourly billing rate, what, 500 an hour, 750 an hour, 3,500 an hour. So if you can take an hour, you can bill full $3,500 instead of 1/12 of that, which comes out to a lot less.
Oh, so they're trying to make it seem like they're being thorough, but they're just trying to extend it to make more money. Why you keep pressing the buttons? Now I can't hear you. What you do? What's going on? I can't hear you. You keep pressing buttons. Can you hear me? Because I can't hear you. Okay. He'll come back in. Couple more minutes, guys, because I do want the judge to sum up this thing. What are they talking about now?
The court wanted us to focus our arguments on anything in particular. Any questions you wanted us to try?
Well, actually, I think what I'm more likely to do is more along the lines of what I suggested before, is give you all a time block and you use the time however you think is more effective. What you think is your strongest argument. I don't, a lot has been covered, and there's a lot in the motions that weren't covered during the evidentiary hearing that I would plan to rule on at the same time as well. So I leave that to you. Mr. Gillen?
Thank you, Your Honor. I know we have other motions to hear on Friday.
Oh, we do?
I thought we did.
I just said disqualification as a whole. So if you have arguments about forensic misconduct, about anything like that, that would be the time for that argument as well.
I consider that part of the disqualification.
Sure.
I thought we had scheduled hearings on the murder.
No, I mean, I talked about that and then things evolved. So we didn't actually send out a notice adding any other motions, but we do need to. We have some trials starting next week. The next 2 weeks, we've got some of our homicide trials already scheduled. So I'm going to be following up with y'all to schedule the rest of the pretrial motions that we have.
The only arguments that we have on Friday would be 1 o'clock on the issue of disqualification.
That's right. All
I
things
don't think it's
disqualification.
StreamYards. I think
Anything from the
think
state or
that-
any other defense
well,
counsel?
yeah, StreamYards probably is just not
All right. Thank y'all.
completely
All right,
compatible
we're off the
with
record.
every different device. All right, so that was it. Waiting for the judge to come back in. So that was the end of that. Final arguments are on Friday. You know, is this judge going to issue his judgment on Friday as well? Hopefully, because now I'm getting tired of this case. Is he coming back in?
Get back on. Somebody called me and threw everything off.
All right, you coming back on?
Yeah, I'm trying to.
Okay. All right, so when the judge come back on, I'm just going to have him give a summation of today, and I want him to go back and elaborate more on this where is it? On the state ethic commission, right? They're basically telling Fani Willis she got 30 days to reply, to their complaint. So yeah. And no Twitter space today, which is fine because I need a break. I'm emotionally drained. Yeah, so this is the state ethic commissions. That's what I want to talk about when the judge come back on. Fani couldn't wait to get Trump. Let's see. And thank you all for tuning in. Fani couldn't wait to get Trump, drag him in, and make him have a mugshot. Yeah, that's right. The mugshot in Georgia, or was it the one in DC? And it would make her famous. Now look, her reputation is at risk. She looks like a fool. Yeah, her reputation is shot. And this is just for this case. Can you imagine if she is dismissed? Her office is going to be dismissed off this case. I think it should. What is going to happen with the other cases? Because now she has the state ethic commissions, that she has to answer to. What does that say for her office in other cases? You have the YSL case going on right now and other cases that, we are not privy to. So yeah, she was focused on trying to be famous to get Trump and not focus on the law. She was not focused on the law. Okay, so that was the famous mugshot in Georgia. Yeah, okay. Because, I'm getting confused. Katie, I'm getting confused. That because he, New York, DC, Georgia, I think that's it. But that was the mugshot. Yeah, he flew in the mugshot and I think he flew in from Florida into Georgia and then flew back to Florida. Yeah. So yeah, she wanted a grandstand. And this is what happens, Yeah, good old selective. What do you guys think that? You think that, Terrence was what's his name? Terrence Bradley was lying. Good old selective memory. He hinted that he was being threatened in some way. Interesting. Really? I don't recall. Well, why didn't you recall when you was on there the stand the first time? Yeah, they all out to get, yeah. And it's like, see, and that's the problem. That is why, and tomorrow when I do my show, I do it by myself and I focus on the migrant crisis, but I'm going to give just a 15 summation of why I'm doing a Fani Willis commentary. But everyone is focused on getting Trump and they're not focused on the law. Because if you're saying this man broke the law in New York, in DC, and in Georgia, focus on the law. And that's really what we are witnessing. What we are seeing unfolding is how our justice system have a lot of corrupt people working in it, that they are not interested in justice. They're interested in fame, in power, in clout. Thank you. So, it's a lot. Where is he? I thought he said he was trying to come back on. I want him to come up before he leaves, before he gets picked up. And he's probably trying to come back on. I'm knocking him off.
Hello?
Are you trying to come back on?
Yes, I am. This is damn fool keeps calling me over and over again. This crazy person that's going in through not even the regular phone. I forgot this. What do they call this thing?
What?
WA business, WhatsApp.
That, oh yeah, you need to get that off your phone. All right, so come on and come up because I want.
Again, I'm trying to block this call so I can get it.
All right.
Give me a second.
Okay. All right. Yeah, Judge be having stalkers, honey. Wait 1 second. What a shit show. Yeah, I wouldn't trust these lawyers to walk. Yeah, and the lawyers kept being redundant. Dana, are you related? Not blood related, but we're family. I've known him now for 4 or 5 years, and he's like, not only is he my best friend. He's my mentor. He's everything. So he's family. We're just not blood related, but we talk on the phone every day. I call him every day. And we talk about everything, especially when it has to do with politics for hours. We do the show, but when we do the show on YouTube, people think that I'm interviewing him, and it's like, no. And really, we really just started hitting a stride with a lot of viewership covering the Fani Willis. So a lot of people that are watching now, they don't know that he's been on my YouTube channel for over 3 years, and the regular people do, but there's so many new people. So we're like family. We're just not blood related. So we're related, but just not biologically. And we talk every day, and we do the show, and we do Twitter Space, right? But I don't interview. Like we host a show together on Thursdays, and then sometimes on Mondays, and he hosts his Twitter Space on Tuesdays. I just facilitate the technical part of it, because he is not about to sit up here and sign into no YouTube and go live. He's not going to do all that because he's too busy. So I focus on the technical of it, and then I add my 2 cents. So yeah, but he's not a guest. I never interview him. He comes on and we talk about different topics. He talks most of the time. I do add my 2 cents. So yeah, she thought she was auditioning. Her career is over, Fani Willis, and we're going to see her next on Real Housewives of Atlanta. They're going to give her a nice check. Yeah. Well, the judge, he was listening to the testimony in the backstage, and he was like, listen, he said this lawyer here, Stephen Sado, he's not very articulate because he kept being redundant with his questions. So, Judge Joe Brown was really disappointed in Trump lawyers questioning because they were redundant. They would just ask some questions, repeat, that they already answered when he first got on the witness stand. That was irrelevant. And like he said, they're doing it to extend it because they're charging Trump by the hour, and all the other defendants are being charged by the hour. So they're milking it. Everybody's looking to get paid. Hopefully I get to bring on a couple of people that could give us some more insight on Fani Willis' reputation in Fulton County. But our system is corrupt. And one of the reasons why I do support Trump is because he always knew it was corrupt. But what he's doing, he's allowing us, the regular folk, to see how corrupt it is. And if they can do it to him, what you think they're going to do to us? And I don't have millions of dollars to play lawyers like that. All right. So before you leave to go shoot, the film and stuff like that, I want to just quickly revisit the State Ethic Commission.
Read it. That's the back page. Read the front page.
Okay. So let me pull it up on my phone here.
What it says is this. It says,
I can read it because I can't make this any bigger for some reason.
well, I can make it bigger. Enclosed, you will find a copy of the sworn complaint of and a list of persons named dated February 19th of this year, which states that you have violated the Georgia Government Transparency and Campaign Finance Act, et cetera, et cetera. You have 30 days, et cetera, to respond to the complaint. And it gives notice summarizing the whole thing that if they find nothing, they will advise all parties. If they find anything that's answerable, they will have to inquire further, and she may be required to participate in some disciplinary hearings. And that means that her law license is in jeopardy. So this is independent of any position as attorney, or not attorney, as district attorney. This is just her competence as an attorney, a licensed attorney. So they will look at it. What
But
you did was open a can of worms,
yes,
and this is just the first one to peek out. There are going to be many more. And then we were talking about some problems in Fulton County involving governmental corruption and such like. And there is some information that is developing that perhaps Ms. Fani Willis has protected some of that. So there'll be more on that forthcoming. I think we will probably have a guest or two or three who might speak on that. However, it's interesting. You see, why are they seizing upon this type of person to put in place to run things? It's strange that the Democratic Party is getting Kamala Harris, same type that you're seeing with Fani Willis, Lori Lightfoot, Stacey Abrams running for governor of Georgia, the local feministas here with the young Democrats. What's the woman's name? I forget, that's prosecuting the civil claim that got the fine against Trump up in New York.
Letitia James.
Yes, it's all the same kind. Maxine Waters, the same. They look like they're all related. Not saying there aren't some very fine women who are attorneys and judges or elected officials, but why this push to get this type in? And Her Royal Highness head scratching Jackson, who just got put on the Supreme Court that did not know what a woman was. Why are they putting this type of contentious person in there? And they're insulting normal, ordinary women. They're insulting women who achieve. And they're putting a type in there that just does not look well. You know, that sister girl magic thing isn't really magic, and it's sapphire. Anybody remember Amos and Andy and Sapphire?
You mean satire?
No, Sapphire, as in the jewel. Sapphire was a character in Amos and Andy. She was a loudmouth, obnoxious female who raised all kinds of hell that was unnecessary and made life miserable for everybody that ran into her. She was a regular character on Amos and Andy. Now, we used to call a certain type of female a sapphire as an insulting term back in the 60s. And I think looking at this, we've got Sapphire Willis, we've got Sapphire Harris, though she's not really black, so it doesn't apply. The character was black. You've got Sapphire Lightfoot and Sapphire Abrams. And why are they picking sapphires to push on the public as a purported leadership cast? I don't get it. Well, maybe I do. It's like the type gravitates to this kind of thing. They have bad self-esteem problems, and they seek offices where they can tyrannically act and screw their way into, for the most part, not saying all of them do, but a lot of them, and or they have frustrations they can't get a screw. And they use these positions to cloak themselves with the charisma, authority, and power of the office that they lack personally. It's a bad thing.
Yeah. Well,
Sapphire.
well, but this is the thing though, because I just look at it. I'm not basing this on race. The only reason why I may allude to it is because Fanny does, Maxine does, and all these other high profile women. It's not about
running in the Republican primary series too.
right. So But the thing is, and I just want to, finish up with the ethic commission. She took the stand over a week ago when she should have just plead the fifth. And one of the reasons why in this situation, Judge, she should have plead the fifth to avoid the outcome with the state ethic commissions and amongst other things, right?
Well, even better still, without even going.
Yeah, I can't hear you now. Can't hear you. I can't hear you. We can't hear you. Yeah. And he can't hear me. I can't hear you. Can't hear you. Can't hear you. Can't hear you. Jesus. Like when somebody calls him and knocks him off the audio. Try it now. Can you hear me? So if I can't hear you and you can hear me, I'm just going to drop you down. All right. He's going to have to come. He's going to have to go out and come back in. Yeah. He's just going to come back in. That's all. We're just waiting for him to come back in. Because if somebody calls him and apparently, there's someone that's stalking him on WhatsApp or whatever, it just knocks him off. It just knocks him completely off. Just knocks him off. But listen, it's not about race. It's not about race. But these women, particularly Fani Willis, made it about race. It made it about her being a Black woman. And that was wrong. That's doing a disservice to a lot of young Black girls and young Black women and just Black women in general. Stop making it about race and make it about the law. Yeah, they make it about race. And that's what I'm saying. The more you make it about race, the more you're going to make it harder for women. And particularly Black women to be looked upon in a negative way. Because it's not. You are, and all the women that we name, whether it's Maxine Waters, she's in Congress, Letitia James, Fani Willis, Ketanji Jackson, they're all part of our legal system and our government. They're all part of our government. And it's funny, they're all part of the Democrat Party. And so as a Black person, knowing that majority of Black people always voted Democrat, the reason part of that is because these politicians, these people in these position of powers, people that work for the government, that is their main talking point to continue to scare Black people. Oh my God, they're racist. If they're white, they're racist. And it's not that. To scare you, to get them to constantly vote for them. No. Stop making everything about race. And you know what? When you take race out of it, and that's for everybody. Black, white, doesn't matter, man, woman. When you take race and when you take gender out of it, then you have to stand on actual merit, knowledge, then we could probably see some true justice in this nation. Dragging the church. Dragging the church. because Black people love the church. You know, it's forgiving. Black people are very forgiving, but the church has nothing to do with it. This has nothing to do with her being a woman, being a Black woman. The Black church has nothing to do with none of that. It has to do with the rule of law. You are blind. So why, if you supposed to be blind to justice, being blind to justice meaning you don't talk about your gender, you don't talk about your race, you don't talk about your love life. That's why you have an ethic commission committee. All right, there you go. Can you hear me?
I hear you. Can you hear me?
Yes. So, you know, just I don't know, what were we saying before? Just you were summing it up. It was race.
Okay.
Wait, can we address this real quick? It is about race. You live United States of America. No. Fani, Kantaji, Maxine Waters, Letitia James, and women and men of those in those positions is not about race.
It's not about race. See, okay, what you see this judge doing, I did that. I was the last judge on the James Earl Ray Martin Luther King thing, and going on 3 years. That was in my courtroom, and there was repeated coverage. It was a Black man in charge. All right. Now, I had 1, 2, 3, 4 bailiffs in my courtroom. All of them were Black. My 3 assistant clerks were Black. My secretary was Black. Several of the parties involved in the whole process were Black. The court reporter was white. And it had absolutely nothing to do with race. The subject matter, one of them dead. Martin Luther King was Black. They had a holiday named after him. And in Georgia does not have a white supremacy problem since it is a very heavily Black city. And you've got a district attorney in charge of the prosecution. The seat from which everything gets controlled is a Black female. So that's not white supremacy. You just have a goddamn fool who is a head prosecutor for a major American city and does not understand self-incrimination. It's a damn fool stunt. A hell of a negative comment. You do not walk in a court acting like that. And if she was sitting up there on the bench, she probably would have been bent out of shape if anybody came in that hand on hip with a dress on backwards, American flag upside down, the pin, and acting a damn fool with her head doing that snake charm thing. So no, this had nothing to do with Black on white, white on Black, white supremacy, nothing. This was just rude, crude, ill-mannered, ill-conceived, and incompetent and boorish. And she's going to pay for it. So she could have easily enough withdrawn the office or removed the office's objection, because it certainly raises questions. You have all sorts of RICO situations about all of this unreceipted, unrecorded cash in terms of the transactions. You've got an implication that she is collaborating with Wade to defraud the state of Georgia into honoring false claims. And I've looked at some of them that they've published, and they are absolutely ridiculously excessive. So you have a big, big problem. And it's not a matter of somebody lying or telling the truth. It'd actually be better for her circumstances if she was lying, because she could have said, hey, the relationship had been going on. We didn't even think about it. It was just one of those things. And he was going through a divorce, and we didn't think it was prudent to say it. We apologize profusely and we withdraw. We've got almost $700,000 that we've made. He. No, they stayed in it. And her contention is it developed later. Well, that makes it worse, because as soon as it developed, she and he both had an obligation to approach the court and advise the judge that they had a romantic relationship. For example, let's say that we have somebody over here, Jane Doe, Susan X, and I get brought in to referee the whole thing and be detached and impartial. And I've got a thing with Susan X that I don't tell Jane Doe about. So am I being fair and impartial? Maybe I can try to be, but it sure gives the impression of a lack of impartiality. You see, there are these things in the law called appearances of impropriety. In other words, if it appears to be wrong, even if it is not wrong, it must stop. And what she is being brought up on these ethics charges is failure to report about $30,000 she said she gave to the campaign. The campaign refunded her about $8,400, which was peculiarly the same amount she owed IRS on a lien that she attested to them that she had insufficient funds to cover the payout. But now we hear she had $15,000 in cash in a cookie jar someplace waiting on a rainy day that she could have paid out to IRS. So they're going to be upset about it. And then we have the implication that they were stiffing the state of Georgia by turning in excessive claims so they could vacation, dine, and party off of it. It gets worse from there.
Right. So now she has the state ethic commissions.
And this won't be the first ethics matter she's going to have to deal with either. The failure to report the relationship as required of an officer of the court will surface again.
So now that she opened up the can of worms when she took the witness stand, now you got the flashlight all up in her colon because you wanted to open up your big mouth, and listen, this is so basically it's not over. Even Friday is closing arguments. But even after that, even if the judge McAfee issues a ruling Friday, it's still, this is not over because of the ethic commission.
Yeah, and see, all we're dealing with is an administrative motion here, which is to remove the district attorney's office for Fulton County and the special prosecutor, who apparently does not have the independence that he ought to have either way. Next thing we come into is if you appoint another attorney general or district attorney to handle the case, you probably won't need a special prosecutor. And that district attorney may do the same thing that special counsel for the Justice Department, Mr. Hur, did for Joe Bozo Biden. And that was, we find probable cause that Mr. Biden committed a crime or a series of crimes. However, we choose to exercise our prosecutorial discretion and not prosecute because of his age and demonstrated mental infirmities. That didn't sit too well, but that's prosecutorial discretion. Another prosecutor in Georgia might do the same thing. In other words, this is a political question. The indictments never should have been brought, and we will leave it to the American public to work this out. It's not up to somebody to abuse the criminal law process for political purposes. They could say that.
One last thing I want to bring to the fold.
One other point too. Fulton County, Georgia is likely to be one of the few pro-Biden areas in the state that's likely to wind up getting selected. So we may just have this whole thing kicked, which it should be, because I looked at the 92-page indictment and it looks to me like it should be subject to an old-time demurrer. What's that? When you file and claim that you have a demurrer situation, it means even if everything that the complainant or complaint alleges is true, there's no crime that's been committed or no wrong that's been done. And that's the way I read it, because everything in there has either been resolved to the contrary at one time or another in the last 235 years since the country came into being in 1789.
Well, this is
It's just like, that's what you have the Bill of Rights for. It's permitted under the First Amendment. So we have essentially an indictment for somebody vigorously exercising First Amendment rights.
And so this is the last thing I want to bring to the table. Like comments like this, single Black woman, take a look. As long as you live within the US, it would be about race. The courts are based on this. First of
No,
all,
they're not.
no,
Because you can't get an all-white jury in Atlanta.
right. So, so the point out, the reason why I highlighted those two.
And let me say one thing about that real quick.
Mhm.
All of you out there who are talking this just us bullshit, have you served on a jury, or do you seek to get off because you have other things to do? Don't stay on the jury and lend your voice to it, and do not be persuaded by people who are talking about you might be wrong. Think about it, and don't try to just get out of there because you can get back to your pathetic business. Deal with your responsibilities as a citizen and as a Black citizen to bring justice.
Exactly.
That's where it comes in. And watch who the hell you elect. You see this clown that you have in there right now, who showed that she has no competence to be in there by what she did to herself. Goodness gracious, that was horrible.
Well, this is the thing though, because you know, before she took that witness stand, you know, even when she would do her press conference, whether it was the RICO law with YSL, or even when she did the press conference bringing the Trump case or whatever, you know, she was being professional. The thing is, I'm not.
What she did wasn't professional.
No. I'm not talking about when she took the witness stand.
No, I'm not talking about the witness stand. I read the indictment. It's not professional. It is absolutely ridiculous, and anybody in the first year law school who's gone through con law would know better.
Well, what I'm saying is the history of DA/prosecutors, they're not liked, and for reasons like this. So she's not the first and she's not the last, you know, or the current DA to be corrupt or, you know, to be arrogant. So her behavior just displays what is allowed in that position throughout this nation. The problem with that is what makes her unique. Look at who you are prosecuting. So first of all, you messed up.
Yeah, in Atlanta, all those young Black kids that get railroaded by the system, you're looking at the person in charge. Damn near every time you get this kind of miscarriage of justice, somebody like her is in charge. We had one here in Memphis, Shelby County. For 9 years it was doing this kind of garbage. Well, 11 years. And was found to be the most corrupt district attorney in the United States. She was a female. The state Supreme Court even said this is the most corrupt prosecutor's office, headed up by the most corrupt prosecutor who still has a law license in the state of Tennessee.
But the point that I'm making here is the reason why it's not about gender or race is that same corruption exists in New York, exists in New Jersey, and they're headed by men. If this,
except one in New York, that woman that is going after
come on, let me make this point. That it's a lot of DA offices that are headed by men that do display corruption. It's not about gender, it's not about race. If Fani was a white man doing what she did, whether, you know, not disclosing a relationship and that type of behavior in a witness stand, it should be the same result, being dragged on the media, you know, having these proceedings. So that's what I'm saying.
I agree. But one thing that I'm pointing out here is this difference. I'll come back to it.
Yeah, come back to it 1 second. So the reason why I'm going down, that reason why I'm pointing that out is when you get comments like this or like this, it's when I bring up her race and her gender, it's because she's using it as an excuse. That pisses me off. But make no mistake about it. This is not about her being Black. It's not about racism here in America. It is not about Black women and, you know, are so bad, especially if this tone is coming from Black men. No, she messed up. She messed up and she is using race and gender, which makes her fuck ups worse. And I'm insulted as a woman, as a Black woman, as an American, that you are using race and gender. And so what I'm saying here, Judge, is she is displaying what, as far as the corruption in the DA office, what so many have been doing for decades in DA's office. However, she thinks she's the exception to everything because she's Black and she's a woman.
I'm looking at something slightly different. Now, I know fine lady lawyers and fine lady judges. They're excellent. They do great jobs. I even had one interesting team in my courtroom. One was a female prosecutor, white, and the other one was a Black female public defender. Now both of them are judges, and they did fine jobs. Excellent. Sometimes had to admonish them about letting their skirts get too short as the trial went on, and imposing the dress codes that we had that I don't think they have now. But there was a certain type of male you could always pick out. He got run home from school too often and got his butt whipped too many times, and he was getting revenge on anybody that came through that reminded him of a butt whipping. We also had females like Miss Fani here, who have bad self-esteem problems, and you could always beat them if you were the opposing counsel, because they would invariably lose track of the case they were prosecuting because they were trying to beat you. And you'd let them beat up on you during the trial, and at the end of it, when you argued to the jury, ladies and gentlemen of the jury, the prosecution had the obligation of proving my client guilty beyond a reasonable doubt and to a moral certainty. However, the prosecuting attorney spent more time trying to beat up on defense counsel than she did on proving her case. So we're left here with an inadequate level of proof, and et cetera, et cetera. Defense rests, jury stays out 30 minutes, comes back not guilty because she fell into the trap, like so many do, of trying to prove something by beating somebody, because everything's a damn contest and she's got to be shown how she's supposed to do it. Now, you saw this Black lawyer who was on the stand being questioned. He said, sir. You heard Wade, he said, sir. Yes, sir. No, sir. You hear the judge doing the same thing. Now, I would point out that some of the defense counsel are rather arrogant, and they're used to working, say, in the corporate sector more than in the criminal sector when they have to deal with juries. But everybody was being polite, but you saw her exactly to the contrary. And then she couldn't leave it in an answer. She had to add on top of it. And the more she added on, the worse it got. So that's what got elected in Atlanta. That's Fulton County, where Atlanta is located for the most part, other than a slice of it that's in Cobb County, which is a bad place too. And it's not white supremacy. This clown was the person in charge of how justice got initiated in Atlanta, and you saw what you got, a clown show. So it was just totally bad, and I felt embarrassed, just really embarrassed.
Yeah, right. And that's what I'm saying. Like, I feel embarrassed when one of us, quote unquote, right, use racism.
That had nothing to do with race. That had to do with foolishness.
Right.
You have the same Constitution. You're in charge of prosecution. I didn't mean to almost say what I did, which was a Freudian slip. But you don't know about self-incrimination? What's the matter with you?
it was that like all logic went out the window and going back to, and so, okay, when you insert gender, so that gives people the conversation of, women in these high power positions at certain points, logic goes out the window and emotions come in, because logic went out the window when she took that witness stand and she was just all emotion.
Mm-hmm.
And you cannot be emotion as a DA. I don't care. What emotion
Issues are yours, not the public's.
Right. You cannot. You can't, even if you're a defense attorney, you cannot. You are the officer of the courts. You cannot.
And that, by the way, is what the issue is there a conflict of interest here that should exclude this DA's office and these, well, specifically this DA and also this special prosecutor? Now, in the process of this, Wade and this woman, Fani Willis, were just witnesses. They weren't on trial. And at the point she came in there and put her hand on the hip in that pink red dress and clowned, the lawyers for the district attorney's office were arguing pretty well with the judge that she should not be required to testify any further. But she walked up in there, hand on hip, threw this sheet of papers on opposing counsel's desk and said, I decided I'm going to testify. Mm-hmm, mm-hmm.
So, listen, Thursday show, I'm probably going to have to title it around like black, something about race, because like this comment here, I think you are failing to realize these President Trump cases are the biggest cases ever. No president have been attacked like this by a political opponent. If Fannie and Wade were white and did the same,
they get jacked up, and you see when you talk about this, you're too young to remember when it was live on everybody's television station, Watergate.
Yeah.
President Nixon, Spiro Agnew, the vice president, went to prison in Maryland and went to prison in the federal system. And it was a huge scandal. This is nothing new. They've got a Confidence of Elections Act of 1877 because the same kind of nonsense occurred then, and they passed a congressional act, which, by the way, was supposed to be the next thing on the agenda for January 6, 2021. But because of the uproar, Nancy Pelosi exercised her administrative authority and tabled it. So what it was is when there is a lack of public confidence in the integrity of an election cycle, the Vice President of the United States shall decline to endorse the report of the Electoral College and shall call for the appointment of a confidence committee, which shall consist of 5 people from the House, 5 from the Senate, and 5 from the U.S. Supreme Court. They shall take at least 10 days to do an independent audit of the results, or such extra time as is reasonably necessary. See, that's because in 1877, they had a big problem. They had problems under the Grant administration, huge scandals going on. They had the Teapot Dome scandals that were going on in the 1920s, huge corruption.
All white
problems. It's not new. They're all white. What the devil are people talking about? Just banish your ignorance and study American history. And if you don't like American history, well, hell, just study the history of the neighborhood you live in, which is the United States.
All right. So I think this is a good discussion of today. And I know you have to get ready to get about of there. You got to go shoot a movie.
Well, audition for it. They wanted me to do this thing. So I don't know.
You need to tell them I don't audition. You either hire me or you don't.
Well, they also just wanted me to meet some executives about trying to do something here for Memphis. We got enough problems our dingbat mayor is talking about, along with our dingbat chief of police who came from Atlanta and got fired for corruption, was about to be fired from Raleigh-Durham, North Carolina for corruption.
In Atlanta. No, she
got fired from Atlanta. They had to rehire her because she was civil service, but she got demoted, and then she left and went to Raleigh-Durham. They were about to fire her there, and then they hired her here. and paying her an exorbitant amount of money. So her solution and the new mayor's solution to crime is, guess what? Identify the criminal elements and pay them not to commit crime.
God. Yeah, and then let's touch on that
They're
one.
talking about having meetings where all of the gangsters show up in an auditorium and he's up on stage because he's scared to mingle with them, and they need jobs and training. Okay, fine. Now, how do you arrange who gets the jobs and the training? And then you have the problem with the gangs have infiltrated the police department, the sheriff's department, school teachers. A lot of them are OGs that have been told to stay clean. Interestingly enough, they don't have discipline problems like the rest of the teachers do, because I guess what happens is mama gets a visit the following day by somebody that tells her what's going to happen to her if she doesn't clean Junior up from acting a fool, or Jamal or PP or whatever.
Mm-hmm. What room is that? I like that room. Can't you just go live in that room when we do the show?
Yeah, well, often it's dark, so you got black around here, and if you
Oh,
try to,
that's sunlight. That light is the sunlight.
yeah, this is
Oh,
one.
it's all sunlight.
Yeah, it's all sunlight.
Oh, you don't have a light in there.
No, there's a sky roof and all of the light around. So,
Oh, I gotta maybe I'll buy you some lights to put in there then.
well, I have lights, but the problem is if you turn the lights on, they shine off the windows.
Oh.
So you get glare.
Oh, I see what you're saying. All right, so
And by the way, this is the place that this new studio they wanted to make a studio in here, so
yeah.
I could do this thing for this talk thing. Of course,
You was telling me about?
yeah.
Are they still gonna do it?
Well, they're talking to my agent about it.
Okay.
Still, I have an appeal, but you know, they blackballed me in Hollywood, but this isn't exactly Hollywood, so it is what it is.
Okay. Well, all right. So, real quick, and I just want to ask you this question. Have you heard of what's going on with Wendy Williams? Are you familiar with Wendy Williams?
I know her.
Yeah. And then
Before she got really big, I was on her radio show quite a few times in New York.
And did you hear about the documentary that came out on Lifetime this past weekend?
No, I didn't. What is it about?
Oh, it's her reality series, and she's talking about, her struggles with grave disease, and somebody on her legal team put her in a conservatorship, so she has no control over her money.
Conservatorship,
yeah. And she's been diagnosed with frontal dementia and aphasia. I'm saying it wrong. APHASIS, I believe, but it's frontal temporal dementia. Aphasia. How you pronounce? I'm sorry.
Aphasia. Don't worry about it.
Aphasia.
Mm-hmm.
But a lot of people were disturbed how she was behaving and stuff like that. So we don't talk about stuff like that. So I don't know, but maybe I could ask you a question about conservatory. That's how you pronounce it?
That's called probate law.
Oh, wait a minute. Hold on. Yeah. So maybe on Thursday, just give a legal education on that whole process. But all right. All right. Thank you, Judge. Appreciate you.
Yeah. It's a weird day. The wind is blowing very heavily. It was below freezing, and then it jumped up 70 degrees with a low high 60s, and then it's supposed to drop back down. Crazy weather stuff.
It was aphasia. Aphasia?
Yeah.
Aphasia. Thank you, guys.
Aphasia.
All right. Well,
by the way, a homeboy that just got through testifying did not make a bad witness. He wasn't a bad witness, Wade wasn't even a bad witness, and you notice how he used artfully. I do not recall, I do not remember, I do not recollect. He wasn't exactly taking the Fifth Amendment, but there's no way to prove that you remember something.
Unless you had said it on a record before.
Yeah, well, you might have forgotten it. I mean, it's been the passage of several years and months or weeks, and this dialogue with about what somebody sent as a text, this is not sitting down at a table and carefully crafting a drafted document that you go over several times and try to perfect. This is something that somebody is sending via text. Now, just think about all the mistakes you make, or whether you can recall what you sent as a text 3 weeks ago. See, this has to do with the realities of human recollection. So it is feasible to say, I just don't remember. Now, nobody can prove you wrong. But if you, instead of saying, I don't remember, let me tell you something. And, oh, by the way, you didn't ask, but I'm going to add. Like,
but I'm going to add.
What's wrong with you? You know, that's the joke with trial lawyers. He didn't ask, but he wasn't asked, but he's going to add. I had some clown in my courtroom, and I knew this was going to happen. And before he took the stand, I had the jury out, and I advised him for about half hour of the perils of taking the stand and testifying on one's own behalf. The state had him charged with aggravated assault, and by the time he got through testifying, he had confessed to 3 armed robberies, 4 aggravated assaults, and 1 assault to commit murder. He was riding around in a taxi. And if he'd kept his mouth shut, it would have been a Class C felony rather than what he wound up getting arrested on. I said, place this, when he got through testifying, I said, take the jury out, please, again. And I said, no bond to be set on this. I said, take this person and charge him with 1, 2, 3 counts of aggravated robbery with a deadly weapon, 3 counts of assault to commit murder, and, you know, blah, 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 blah.
Mm-hmm.
So that's one of those.
Yeah.
That's one of the cases, you know, where it shows it. And this woman did about as bad.
Yeah.
I've never seen any. Well, yes, I have. But I have seldom seen anything except a real dumb crook pull off these kind of stunts. And this was the DA.
Well, all right.
I mean, the judge, he could have broken it up, but he was probably debating on how embarrassing it would have been to stop everything and advise the district attorney of her Fifth Amendment rights. Ma'am, before you testify any further, the court will.
Maybe he felt like she's a damn DA. Do I have to remind her something?
I know that. That's like pretty sound argument. You know, Your Honor, why should she need to have her rights read when she is the head prosecutor in this jurisdiction? Your court, Your Honor, is in her jurisdiction as chief prosecutor representing the people of the state of Georgia.
So I put a poll up. Do you think Terrence Bradley was lying on the stand? 90% said yes, 9% said no, 280 votes. So, you know.
Well, here's the thing. The way he did it, you can't prove it. And the way they went about cross-examining him was awkward. There were more effective ways of cross-examining that kind of witness. You tried to treat him as hostile, but when you tried to treat him as hostile, you got absolutely nowhere because he knew what you were doing and he's playing at the same chessboard you are, and he might be able to play chess better than you do. So it didn't come across well. It was very awkward and clumsy. Not totally, but for the most part. And they kept fishing and asking things awkwardly instead of just saying, well, why did you do that? Well, you can lead a witness when you're cross-examining them, but sometimes you just ask, why did you do that? You might get something. And they were also doing some other things too. asking questions they did not already know the answer to. That's a no-no when you are cross-examining a witness in a criminal case. Do not ask anything you don't already know the answer to. And when I gave the first example, all right, why did you do this? You already know basically what the parameters of his answer are going to be. So that's a safe thing to ask. But it's like, wow, where is your art? See, to a great extent, a trial lawyer has to have the same kind of skill set that a stand-up comedian can do when he's working the audience. He can extemporize and he can be witty. He can be sharp on his feet. It's like most of these youngsters don't know about it, but we used to run the dozens. Hey, man, I want to say something about your mama, man. Well, man, you talking about my mama, man? What about your mama, man? She was blah, 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 blah. And see, this witty repartee and comeback. And you didn't see that.
All right. Well, let's close it out. Thank everybody for tuning in. Like and share this video. We will be live on The Real Dano on YouTube Thursday for Man Up Thursday with Judge Joe Brown. No X Space today. And yeah, have a great week, everybody, and see you on Thursday. Say bye.